What other officers were in that area sort of watching what was going on or participating in the search for what was going on?
I don't necessarily recall where everybody was, but I believe it would be Sergeant Link and Sergeant Good.
And they were superior officers, correct?
Correct.
And you understood that these brother officers of yours were looking for evidence, right?
Yes.
They were looking for clues about potentially what had happened to John O'Keefe, correct?
Yes.
And you were paying attention, too, as they were doing their work, correct?
Yes.
You were looking for anything that might have been out of place, correct?
Yes.
If there was something large there that didn't appear to be appropriate for a front lawn, you would have made note of that, correct?
Yes.
And if there was something small there, you would have still made note of that if it didn't appear to belong on a front lawn, correct?
Yes.
At any point in time, either before or after the leaf blower was taken out by Lieutenant Gallagher, did you see 45 pieces of bright red, black, and clear plastic pieces scattered all over the scene?
I did not.
Did you find or see even one piece of broken plastic?
I did not.
Welcome, Mike Crawford, Young Jerks. You're at the right place tonight. We got great guests again. Exactly what you want right now. Just had day 2, police officers, EMTs, witnesses for the prosecution. I don't think it went well for the prosecution, but let's get the expert up here and let's get the pulse of Free Karen Reed, Mazza Media, and then the legal expert. We got the attorney back, criminal defense attorney, Mark Bederow. So let's bring them both up together.
Good evening.
Hey, gentlemen.
How are you?
Good. Where do we start tonight? Because a lot of testimony yesterday.
2 days, 2 victories, Mike. 2 days, 2 victories.
It sure seems like it, right?
I think they had as we talked about previously, a pretty bad first day. Although it may not have been as dramatic as the first day, the second day, I think, was actually worse, if you can believe that, because, you may not have known it from the opening because it was very confusing. But the bottom line is, if things were going well for the prosecution, they would have had witnesses come right out of the gate having a jury feeling, my God, this woman made multiple admissions of guilt of something. Not necessarily murder, not even necessarily an intentional act, but if you were to stop listening after the direct examinations of some of these witnesses, you would have believed that Karen Reed said, this is my fault, I did this, or perhaps even more dramatically, I hit him, which, if a jury were to believe that, would clearly suggest that this was a car causing death. And if the jury credits that, that would wipe out a lot of the defense, because the defense clearly is, I don't know what happened. I wasn't there. There was no accident. I didn't hit him at all. And, so this could have potentially been for the DA the way to argue that this conspiracy talk is all nonsense. Instead, the conspiracy theory for the defense just got rocket fuel thrown on it in support of it, because these witnesses were terrible, either for being unprepared by the DA, which is inexcusable, or for the DA not softening the blow and once again telling the jury what might be coming and offering some kind of explanation for it before the defense pounces on it. But, really, both of these critical witnesses who allegedly were going to establish that Karen Reed made a series of admissions were left being, at best, unreliable, and at worst, something much more devious, which is, are they part of a conspiracy? And let me just speak to that real quickly. I don't think anyone would suggest that either one of these guys fits the profile of, how are we going to do her dirty, and, what do we do to frame her? The theory, I think, that they would have been part of this is after the fact, as the investigation was going, as the alleged corruption and cover-up starts, that either this Proctor or others might have influenced them, encouraged them, told them what other witnesses were saying, such as McCabe with this story of, I heard her say this. But, but by the time these guys get off the stand, let's put it this way. When you express extreme confidence in facts, such as what somebody was wearing, and on direct, by the way, not on cross, on direct, he kept bringing up the puffy jacket, the winter clothes, the jacket. It's almost like he was prepped for this. And what I can't understand is how this DA show him the pictures in advance of testifying. I mean, in your office, not in the courtroom. Show him the pictures. And if nothing else, I'm sure he wouldn't have testified that the guy was wearing a puffy jacket and come off the way he did. And if you looked at the EMT, the young guy, he just looked defeated by the end of this, and body language tells a lot. And by the way, this is why you need jurors to be able to see witnesses. For that, a lot of people were poo-pooing that's defense nonsense. It's not. You needed to see that EMT who looked like, from one of those commercials, you want to get away. That's how he looked at the end. And, you almost sympathize with him, but he clearly was discredited, and the cops are off. We'll talk about him. He was even worse.
Now, you said they were unprepared, the witnesses. I think you just mentioned one of the things about the jacket. Like, how do you think they were unprepared? Like in different instances?
Some of this is hard because you come from, when you do this for a living, you're always critiquing, and you just can't help yourself. And, how would I do this, or how do experienced lawyers do this? You have to assume that somebody like Lally, who has been living and breathing this case 7 days a week for 2 years, would know, and clearly he did, what John O'Keefe was wearing when he was found on the lawn of the Alberts house. I mean, I think we can all agree, whatever Lally may or may not be, he would have known that. And you would think that in prepping the EMT, who again has really powerful testimony, if you believe it. I hit him. That's, again, that wipes out everything. Now it's a car accident. That's, or worse, that really would narrow the case down. That you might, in prepping him and what is he going to say, show him pictures. Is this what he looked like when you found him? What do you see? Anything at all. You prep him. If he said he was wearing a coat during the prep session, show him the pictures. Are you sure? Take a look. Does this refresh? Whatever. I'm not even saying you're telling him, let me tell you what you need to say. Just honestly, does this help refresh anything? And instead, this kid goes off the rails. He's wearing a puffy coat. He was wearing he had his winter clothes. He had his jacket, his heavy sweatshirt. I mean, it sounded like they actually went the other way and wanted to prepare on this. And they don't have the pictures. They don't use them. And it takes 5 minutes on cross for, a skilled lawyer who actually prepared for the examination to expose this. And once you expose this kid, everything he says is going to be discredited. And it doesn't mean that he's dirty or anything, but he expressed extreme confidence in his ability to recall what happened, including the jacket. And once that was wiped out, it calls into question anything he said about how carefully he remembers. And then you add on top of that the fact that even his story about the statement, I hit him, was also not consistent. I mean, it goes from, I heard that she was talking to someone else, or I overheard it, or it was in response to a question from me, which I got to tell you doesn't make much sense. And I'll tell you why. Because this guy is an EMT, and he spent 90% of his testimony saying, I'm there to triage and assess what am I dealing with. This is why I do certain things. This is why I take off their clothes. I need to know this. This is why I need information, because I could possibly save a man's life. So I would suggest to you this: if that really happened and you're doing this assessment and some frantic woman comes up and says, I hit him, I don't know. You might want to know, ma'am, what do you mean? Did you punch him? Did you hit him over the head with a club? Or did you run him over with a car? That would help him assess what could have happened. And he just left it there. He said, her response was, I hit him, to his question of what's going on. And he didn't follow up on that. And then, given that initially he claimed he overheard it, it becomes unreliable, and the witness becomes unreliable, and you could see his body language change. And I don't think this kid meant to do her dirty, but he's not a good witness. And anyone who's telling you online or on Twitter feeds or any of this stuff that, oh my God, I hit him, is this powerful testimony.
I would not consider his testimony to be powerful at all.
It's not. It's not. And if it was corroborated by other credible evidence, then you might forgive it. But the problem is it's discredited. And the worst part is the way the DA does this, it immediately follows this cop who says, she admitted she did it. She told me it was my fault. And the idea that they thought that would be a good place to start, knowing that his story was going to be, well, I had an oversight. Again, this goes to lack of prep. The DA knows that we have a problem. He's going to get crossed about why didn't he write this down? And his answer is, well, it was an oversight when I didn't write it down. It was an oversight when I didn't tell Proctor, a week later, whatever it was. But 2 months later in the grand jury, I have this great recollection. And then, of course, you have the problem of listening to the dash cam, which clearly indicates, even if you listen to it just in court, where I know the quality wasn't good, but you could hear clearly what she's saying. And she sounds like a distressed woman whose boyfriend was hurt, and she was concerned. I left him, and whatever it is what she said. And I know the video was enhanced. And this is just another incredibly bad day for the DA. And I think, to close this point until you enhance this should have been their opening salvo. This was going to lay the foundation for everything. Okay. The conspiracy is nonsense. The McCabe's and Alberts, this is all garbage. This was a car. She ran over him. This is what happened. And instead, what you got were these witnesses who, within 5 minutes, by an experienced lawyer, were discredited. And you had cops who said, well, I didn't find any taillights. And yeah, there is a woman who is in fact going in the house, but the cop says, I'm a first responding police officer, not paramedic. Paramedic's going to go straight to the man in distress. I get it. Police officer, once the paramedics are there, ought to be doing, I don't know, police type stuff. What happened? And he basically said, I have no interest in going in the house. It's against protocol. Are you kidding me?
Right.
It's against protocol to ask questions of potentially someone who owns the house where, a Boston police officer is lying dead on the lawn. And I got to tell you one last point on this, guys. The conspiracy theory, there are bombshells, and then there are just little breadcrumbs, which make you wonder. Okay. And sometimes those little details help. And I loved the way Jackson came out initially with the dispatch report. How in the hell does it have the wrong address and the wrong times? And, I know it's prepared a little later, but if there was nothing else, you'd say that's not a conspiracy, that's a typo. But given the effective opening that they gave, where they said this is all part of that, right out of the gate, you're saying, why didn't they say this was Albert's house? What are they hiding?
They were hiding his address. I mean,
And
that seems clear to me too. Like that, it definitely seems clear that that's going to go that way. There's been a lot of talk online about that.
It
definitely,
does.
Yeah.
But it goes back to what happened the day before.
32 versus 34.
This is why you need a theme. And the defense in their opening gave you the theme. Karen Reed was framed. Here's how we're going to get there. The DA gives you this word salad of nothing. And then he even calls these witnesses. And even though these witnesses were discredited, even on their direct examinations, he buries the lead. Did you notice during the direct examination of the EMT, where again, we're droning on, it's like, are we going to get to the point? I know jokes have been made. We're talking about the weather and this and that. And he just nonchalantly, sometimes, maybe 80% of the way through, no dramatic motions, no modulation change, tip the jury off. Here it comes. Wake up. I've got something for you. He just nonchalantly elicits this, I hit him. And then he just kind of goes on to the next question, goes on,
Drones.
and drones on for 10 minutes and says, okay, I'm done.
That's
Should have
it.
ended with that. That's what you end with.
Right. Big finish. Like, it's obvious. I mean, we've all watched movies. I mean, it's the same thing. Yeah. I do, like when I do journalism as a journalist, that's what journalists do. The same thing. It's like you gotta, it's just obvious. Yeah.
Primacy and recency, right? The first thing you say and the last thing you say are what people are going to focus on. And he just buries the lead on everything he's doing. And, I'm not trying to be biased here. I certainly have views like anyone else about what's going on here, but this is going awfully. And some of the commentary that you see online, I mean, the court TV stuff I saw watching because I had to watch their link to watch. I wanted to watch the testimony today,
Okay.
and they were commenting just on the direct examination of Sarov, saying, "Oh my God, she admitted it, and this is powerful, and he's doing a wonderful job." Now, that's not really the case, but the thing that was stunning to me was that the court TV host, and the legal experts were rendering opinions, almost like opinions of finality, halfway through a direct examination without even hearing a word of cross. And anyone who understands how these things work recognizes that nothing will give you the truth more ever than cross-examination. And you should never make up your mind about what you just heard or saw until there's cross-examination about the facts and about the credibility of the witnesses, about their ability to recall, and all of this stuff. And it was bad.
Yeah. I mean, you could even deduce info if there is no cross, right?
Yeah, sure. I mean, look, one of the witnesses yesterday, I think it was was it the victim's father? There was no cross.
The brother and the wife,
Right.
of the brother.
There was no need to cross-examine him. What are you going to do? I mean, the guy's brother is killed and lying dead on the lawn. I mean, he has no substantive knowledge. No. So an experienced lawyer does exactly what they did, which is, I've got nothing to say. My condolences, and let's get back to it.
Absolutely. This is Mazza Media. What do you got on all of this?
Yeah, I'm going right for firefighter Timothy Nattell tonight. My opening statement here, which I'm preparing right now. I'm just going to read it verbatim because I've been writing it while I've been listening, because I just wanted to get
I'm
this
ready
out
for
here.
I'm ready for a Mazza. Like I don't, what do we call these? Because you go.
Mazza live tweets, I guess, so we can go with that tonight.
No, but this is the live show. This is the Mazza live. Like sometimes you get on a roll. I can't wait to hear what you got.
Oh, I'm gonna go here. So this is my theory that I'm gonna bring up. I brought this up yesterday. I'm gonna bring it on the show tonight. Here we go. Is it out of the realm of possibility that Canton firefighter Timothy Nattell had actually heard Karen Reed say, "Did I hit him? Did I hit him? Did I hit him?" and not "I hit him, I hit him, I hit him," as he claims? Karen Reed made it clear in a TV interview with Nightline last year that she had stated, "Did I hit him?" in the form of a question. Karen Reed's attorney, Alan Jackson, asked a brilliant question to Nattell during his time on the stand yesterday. He asked him why he didn't report what he heard to anyone. "I hit him, I hit him." Jackson followed up by saying that Nattell never mentioned this to anyone, not a cop, a fellow firefighter, or anyone at the hospital, until he spoke with Massachusetts State Police Officer Michael Proctor on February 8th, 2022. It is important to note what has been heavily alleged for quite some time now: the theory that Proctor, while he was writing down the names of individuals who were inside of 34 Fairview Road the night of the murder, had blatantly misspelled several names. If this is so, then it's not far-fetched to theorize a possible scenario where Nattell may have either misheard what Karen said, failed to properly recall what Karen said, or my key point, was influenced by Proctor or colluded with Proctor to change his claim of what he heard from "did I hit him" to "I hit him." And that is a theory that I have right now. That I started to think about it when I was watching it back the second time. That is not. It's a plausible scenario. I'm not going to say that's what it is, but I am going to suggest that that's in play because we know. Go ahead, Mark.
You put your finger right on it, and this is what a skilled attorney will say. First of all, that theory makes total sense. It doesn't. I mean, you can't prove it, but the key word you used is plausible. Again, the burden of proof here is all on these guys, and if the defense puts forth a plausible explanation for all these kinds of things, then that clearly is going to support a finding of reasonable doubt. I mean, the whole idea, why didn't you tell someone this could have been what did it? I don't know. And it all comes after they talk to Proctor, as you said. And what you said makes perfect sense. It fits the whole defense narrative. And at the end of the day, this is all going to be viewed through the lens of the puffy coat, the winter clothes, and I'm positive about that. That's what he had. By the way, which begs another kind of interesting question. Is there any evidence that when O'Keefe arrived at the Albert House, whether he went in or didn't, was he wearing a coat? I don't know. Is that, was that destroyed, or was he just not one of those guys who likes to wear winter coats? A lot of us.
I heard he had a pullover, just like a hoodie.
Okay.
Gray hoodie. I think it was a Patriots hoodie, actually. Wasn't it a Patriots hoodie, Mazza?
I didn't get confirmation of that, but I know he was wearing a hoodie when he was at CF McCarthy's when him and Karen stopped there before eventually going to the
No
waterfall.
jacket.
But do we know?
This is the first I've heard about this. Turtle Boy even said this yesterday too. It's the first we've heard about it. We never heard about. That was a question I had months ago, and we just finally heard something about it.
If there's a video of the last known time he was seen alive in a Patriots hoodie, and again, when you're watching, it's hard to see what the photographs show or what they're talking about. Is there any evidence that when he was found on the lawn that he was wearing a Patriots hoodie? Because here's the thing. If Karen Reed dropped him off and then plowed him over and left him to die, he ought to be in a Patriots hoodie. No?
Yeah, exactly.
Do we know that or not know that?
I would say this. I would say that it would not be, considering the time frame and the weather that night, it would be more likely that he would have added a layer of clothing than take an article of clothing off. So I would say that it would be 100% plausible that he would more than likely have worn the hoodie or a jacket over the hoodie than not worn the hoodie at all. And there's a picture I got from CF McCarthy's on Google that does confirm. It doesn't show the Patriots on it, but he is in a hoodie. It's a thin layered hoodie. It's not like thick. It's not like too thick of a sweater, but it's there. I'll send it. I'll just message you, Mike, if we want to display it on the show.
Yeah, somebody even described it as a long sleeve T-shirt with hoodie, like you see.
Yeah, I'd say similar to that. Yeah, it's not very thick. Yeah.
So, yeah, I mean, there's so much. I'm glad you brought up, in addition to the address issue, having the wrong address reported, basically. There was also what Mazza Media you just brought up about all the names that were misspelled, all the witness names in Proctor's report.
That's what hit me, because I'm like, how could he have heard her say this? And I know she said what she said, but the thing was I was, when I was theorizing about this last night, I said, well, is it possible he heard this? And then my mind's like, well, did he make it up? I'm like, no, because Karen went on Nightline last year and she very clearly corrected the reporter, because the reporter posed the question, did you say I hit him? I hit him. She goes, no, I didn't. It was preceded by did, and it was proceeded by a question mark. She said that pretty much verbatim on the air. So I'm like, so she admits that she did say something in that realm of possibility, but she was so certain that she was saying, did I hit him?
You raised another interesting point. I'm a little surprised, to be candid, because I watched that interview today too, with her. I wanted to see that in light of what happened in the testimony. And I understand the public interest in this, and she projects as a very sympathetic defendant, obviously. I mean, look at the amount of supporters she has. But I will confess, I do question the defense strategy of putting her on TV, having her speak, even though she came off well. You are locked into certain things, and I'm not suggesting it's a game where, you say this or that, based on what day of the week it is, but she is publicly on record at least wondering, did I hit him? To your point, what you're just saying. Not that that's incriminating, but, that is a fact now, not in evidence before the jury, but, they can't walk away from that because, that could blow up in their face. And I question respectfully why they would have put her on as opposed to just have the lawyer.
Parents or the lawyers. Yeah.
Parents, the lawyers who were very effective mouthpieces. And, when there's an open criminal case, you have to be very careful about putting something on.
Yeah.
It could be used against you.
She did a lot of press. She talked to this Boston Magazine reporter that apparently is going to be subpoenaed about her off the record conversations with Karen Reed.
Well, that's where I get concerned. I mean, not
So,
that again, she said anything terrible, but anything that just adds complications to what you're trying to do.
It seems like to me that the point they were making with that was like, she's innocent, so we're not going to hide it. We're gonna show how innocent we are. We're even going to take risk here and show like that.
Oh yeah, no, I mean,
I think it's the less is
It's a
more
gamble.
philosophy that Mark's arguing, right, Mark? A less is more argument. A less is more argument is, I think, what you're trying to make is don't present more cards to the table than need to be presented.
What I'm saying is you're winning, and you were winning back then, and at all times during the course of this investigation and case, you're winning. I mean, there's so much reasonable doubt. Even the indictment itself is so flawed. I don't even know why they would have indicted her based on this evidence. And certainly she had public sympathy anyway. Do you get more sympathy by saying, we're not ducking anything and look
You're
how
right. You're right. I don't think it made a difference. You're right.
Well,
like it just that interview.
And there's one other big concern I have. And again, it's optics and whether jurors follow what they're supposed to do. One of the risks of putting a defendant on camera and saying something and jurors know about it. Now, again, this was months ago, so the jurors may very well know that she had no problem telling a journalist what happened. Now you get to trial, okay? She doesn't testify, which I don't believe she should. There's no reason that she should. There's no need for her because she's winning and almost certainly is going to win based on the evidence. But, jurors are human. Never mind the judge's instructions about you don't draw any inferences from defendants who don't testify. You don't want jurors who are going to take, the Wendy Murphy theory of you're guilty. I'm not saying it's that bad, but what I'm saying is, do you get concerned if there are people who say, how come she was willing to talk to a journalist but wouldn't answer questions in the courtroom? And that is another reason why I feel it probably was not worth the pros and cons being weighed to put her out there, because look, those two lawyers are good. We know that. They can make the case publicly. You put her family on, they can be sympathetic, and you have a perfect answer, which is, the client is fighting for her life. So, she wants to talk to you, but, she's listening to her lawyers who have basically told her you can't. And, she wants to punch us in the mouth because she wants to speak to you. But, we can't allow that just because we're cautious lawyers. So I do think that was a miscalculation.
Definitely. Let's talk about this other officer that you suggested we play some video from. We could play some. We have it queued up.
Yeah, that would be good. Yeah.
You want to play a little bit?
Yeah, let's
the
play it.
Tariq
Yeah, a
guy?
little bit. Sheriff. Yeah.
Oh,
Yeah.
Sorry, I spoke ahead of you, Mike. Sorry. I gave the name away.
Is that how you say it? Sarif?
Saraf, yeah. Saraf. Yep.
Let me get this.
These are the two witnesses or people that were on the stand yesterday that myself, Natel and Saraf, that I thought were the most striking moments of yesterday.
Oh,
Sarah. Is it on the screen right now?
Yes.
It's coming up. Yeah. It's displaying. Yeah.
Or modify about your testimony yesterday? You thought about overnight?
No.
Did you discuss your testimony with any person between the time you got off the stand yesterday and coming back to the courtroom?
No.
Officer Sheriff, I want to ask you a couple of questions about something called a dispatch log. Do you know what a dispatch log is?
Yes.
What is a dispatch log? Can you describe to the jurors?
Notes saying what time calls come in, and sometimes a short synopsis of what happened on the call.
It's an official document generated by the Canton Police Department, correct?
That's correct.
And it's kept in the ordinary course of business.
Yes.
It's created at or near the time of the event that it's recording.
Yes.
And it's supposed to be accurate.
Yeah, right, yes.
Is that yes?
Yes. That's right.
And in fact, what it has is the dispatch details of the event that's in question. Whatever officers show up, what time they show up, the order in which they show up, the location to which they're dispatched, things of that nature, correct?
Yes.
Have you looked at the dispatch log in this case?
No, I have not.
May I approach you on it?
Yes.
This has been pre-marked as Exhibit 27. That, so we can recognize that document.
Let's skip ahead.
Were they in the same?
Cook Unity
Oh,
is a
God.
direct-to-chef
I hate when
The last
my own account. What's
from the
go ahead.
video review I did yesterday, the last 5 to 6 minutes of the time he's on the stand are the most
Yeah, that's what I was
notable.
just gonna queue up.
Yeah.
I thought I had it queued up right, but I don't. Let me what can I do here? I don't want people to have to watch extra video, extra ads. Here we go.
The individuals to the left of the SUV right here. There's a person wearing a hood with fur on it. Is that Kerry Roberts? Do you remember?
I don't know.
There appears to be another person in a darker jacket standing just in front of that person with the hood with fur. See that person?
Yes.
I'm going to ask you to focus on the person in the darker jacket.
Sure.
I believe, and the only reason I'm asking you to focus at this point is because I want to try to play this just once and see if you recognize what's depicted in the video.
Sure.
What I expect you may see is this person move out of sight behind the SUV, and then in the background there's an SUV parked in the driveway. Pay special attention to that portion of the SUV and see if you see that person in the dark jacket pass from right to left in front of that SUV as if they're going to the house. Pause it. Have you seen the person in the dark jacket leave the view?
Yes.
Did she appear to go behind the SUV?
Yes.
Okay. Go ahead and play it. Go ahead, stop there. And now I'm going to ask you to draw your attention to that car with snow on it. Pay special attention to that car as the film continues to run. Go ahead. Pause. Do you see a person standing in front of the car?
It appears to be a person. Yes.
Walking from right to left?
Yes.
Would that be toward the house?
Yes, it would be.
Okay. And also, if you wouldn't mind switching your perspective, now you're looking more at the front of the house. Continue watching the film and see if you see that same person walking toward the house. Stop. Did you see that?
No, I didn't see. Oh, yeah. Yes. I saw the shadow. Yes.
Right. Shadow of a person
Yes.
walking toward the front of the house. That was Jennifer McKay going into the house, wasn't it?
I have no idea.
Was it a person going into the house?
It was a person. Yes.
Did you get anybody any permission to go into the house?
No, not my own.
Would you think that a witness in a homicide scene, go ahead and raise the lights, thank you. Would you think that a witness at a homicide scene being allowed to go into a house to make contact with other witnesses?
I didn't know it was a homicide scene, sir.
If I could finish my question.
This was a pretty amazing part.
It is, and it, you know, you start with, again, this guy clearly has never seen this video, and that's just stunning to me. In the course of 2 years, how has this DA not sat with this guy, played his video, and said, "Tell me what you see. What's going on? Is there anything I should know? Do you know who that person is? Who's this? Who's that?" And it also suggests potentially that, did the DA even know what it is? Because they clearly knew who each individual was, meaning the DA. And if they watch the video closely, it appears to, as the lawyer suggests, show McCabe go right into the house at a very strange time, given some of the other evidence that's coming down the pipeline with phone records and calls and deletions and all that stuff. And at the end of it, you don't get anything where this guy says, as a police officer, I just got called to a scene where there's a dead police officer or close to dead police officer without a coat on, one shoe on, who is not a drug or alcohol death. He's physically, his eyes are almost popping out of his head from what they're saying. He's got clear trauma to some extent on his body. And the woman who was part of the reason for calling starts to kind of slip away unannounced into this house. And there's nothing about where are you going? Who are you? Is there anybody in the house? Who lives in the house? Who owns this house where this dead body is lying on? Does anybody,
Right.
or what about, does anybody know what happened?
Exactly. Knock on the door to see, did you see anything?
My God.
They
It's
did. Yeah.
just
So-
awful.
Like if we see weeks of this, because they're going to bring up more police officers tomorrow morning.
Great.
What time do we know what time this starts? Is it 9 a.m. or 10 a.m. tomorrow, Mazza? Do you know?
I don't know the exact time, but I do know it's a half day. Judging off, I think the last day, Tuesday was a half day. I think it may be 9 o'clock tomorrow. If Scott McGinnis is in the comments, he gave me the dates yesterday, but I think it's 9 a.m. We'll stand by for correction on 9 o'clock.
It is
being
9
confirmed
tomorrow.
now. Yeah.
Okay. So 9 a.m. tomorrow it starts. We'll be back streaming it too. It's crazy. This is crazy stuff. I definitely want to play more from this guy tonight. Who's beeping? Is it me or somebody else?
That's me. I'm getting
that is you. You got an urgent call you have to answer?
Nope.
Or is it the Celtics game? You getting updates?
No,
Celtics game starts in about 23 minutes.
No, we're good. It's okay. The Celtics game will be off to the right. I'm okay.
I got a question for Mark real quickly here.
Yeah.
Going over the lack of preparation for Officer Sarif in this particular situation as it pertains to the video, is it possible that perhaps the DA's office and whomever else had seen this footage previously had not followed that video as closely like Alan Jackson and Karen's defense team had to notice that little moment in the distance? Is that out of the realm of possibility?
I mean, at this point, given the way, they seem prepared generally and just their manner of presenting a case, I don't think anything's impossible with, their lack of competence, professionalism, whatnot. However, to be fair to the process, I can't fathom that for 2 years, and again, they brought the murder case. This is on them. They're the ones who want to do this, right? Nobody else wants to be here. I find it really hard to believe that they would not, between the investigators that they employ in the office, between the police officers, the lawyers, watch this carefully, attempt to enhance the video, look at it. And I can't fathom that they would not notice that McCabe is, creeping in the background into the house, particularly in light of they know what the defense is going to do. I mean, they've got McCabe in the crosshairs for something, right? Either she knows what, according to them, knows something dastardly that happened in that house, all kinds of things. And moreover, presuming that they've interviewed McCabe many times, they would have asked her, what did she do? And then the interesting question is, what did she tell them? Did she say I went in the house, or did she lie about that? And if she did, did they tell the defense? Who knows? But I just can't believe that even these people, as out of their class as they appear to be, to bring a case like this, would not know that you can see McCabe clearly going in the house while all this craziness is going on outside.
Now, we've had some people in the comment section the last couple times we've had you on, Attorney Bederow, who have commented on some big cases that you've covered in the past. One of them you were mentioning to us in the private chat before the show, how it's similar to this case. Can you tell us about that?
Yeah, similar in just how I feel, how it's going to end, or how it's just awful, not factually. This was a case in Brooklyn that involved a former supervisory FBI agent, retired, who was the head of an organized crime task force here in New York, who ran a very notorious informant in the Colombo crime family, and who this retired agent was later indicted for 4 counts of murder for being accused of telling his informant things and having essentially the Colombo crime family commit people because allegedly, according to the Brooklyn DA's office, the FBI supervisor was leaking information to the mob to have, to help his informant kill people. His name was Linda Vecchio. It's all, I mean, it's a well-known case. It's a well-known thing. The informant was a guy named Greg Scarpa, who's very famous if anybody knows about organized crime stuff. But the case was so flawed from the inception, and they investigated it for a year, and we continuously tried to talk them out of indicting him. All the witnesses were awful. They were all former mafia members who had previously cooperated with the FBI, given sworn testimony, which was entirely inconsistent with the client, of course, being involved in any of these horrible crimes. And they also relied upon the informant's wife, who was the worst witness imaginable. And we would sit there and say, I can't believe they're going to do this. They can't really do this. And it's kind of how you feel about this case. Are they really going to do this? Okay, they did it. I can't believe they're really going to try this case. I can't believe it. And they did, just like they're doing now. And what happened in our case was we didn't even get an acquittal because it didn't even go that far. The DA literally quit in the middle of the trial because the whole thing just on a daily basis would blow up in their face to the point where the key witness just spontaneously combusted and imploded to the point where they just said, we're done here.
Now, was Scarpa the main witness?
No, Scarpa was dead by then.
Okay.
His gumata, as they say, was the witness. His wife, girlfriend, whatever she was at the time, who claimed that Greg Scarpa told her everything that was going on in mafia life. And I mean, she was.
This sounds just similar to the Turtle Boy stuff.
I'll tell you something. The Departed is loosely based on this for sure.
Yeah,
it's very similar.
Yeah.
To put a little Boston touch on it too. Not Italians, Irish, but very similar type of thing.
Wow. So crazy stuff. So you got this FBI guy off. He was innocent. He didn't do that crap.
He was absolutely innocent of all those crimes, but the case blew up and was dismissed. And I'm not literally predicting that'll happen here, but I have that same feeling saying, how is the DA going to get to the finish line when they're literally 5 minutes out of the starting gate and they have already had what really, for their theory, should have been the perfect foundation to get them off and running? We have credible admissions of guilt, and now we're going to have broken taillights, and we're going to have all this other stuff that's going to show that this was her version of road rage to kill him and this and that. And instead what you have is Saraf, who, my God, just not exactly what you'd call best practices for a police officer in many regards for responding to unusual death scenes. And again, the EMT, whose admissions are even worse, really, because they're specific to a car, really. I mean, if you think about it, but both of them have been discredited to the point where, and this is important too, the jury can discredit them without having to believe, oh, they're part of the conspiracy. And don't underestimate the significance of that, because I think a lot of people are not going to believe, particularly the EMT, who seems like an earnest enough guy, but on the other hand, he had so much confidence in what he remembered, and it was so obviously wrong.
Right.
That at that point you can say when they go to summations, how reliable is he? And he's not. And here's why And with Saraf, I mean, it was an oversight. Here I am. It's my fault. I did this. Officer, most cops in that situation, when they look at a dead man, a dead man lying on the lawn, and these people come up to them and somebody says, this is my fault. I did this. Not that I'm an expert in, solving crimes and investigating things, but for the love of God, officer, you might want to say, did what? What are you talking about? And this guy never did that. He just kind of said, all right, let me put you in a car. Don't worry about it.
Don't worry about it. We'll figure it out. We'll figure it out later.
And I got to tell you something. And I always go back to this because I feel bad for the O'Keefe.
Isn't he a cop? I mean, every cop I've ever been around, especially in that type of any type of situation, they pull you over. They always ask you questions. That's what they do. And they ask you questions. Do you know how fast you were going?
I was just going to say, I feel terrible for the O'Keefe family to have to listen to this because, she's going to be found not guilty, almost certainly, if it even gets that far, as we said. And at this point, I think you have people online, you have a very credible argument to seriously believe that she's probably actually innocent. I think there's a lot of evidence to support that. And to sit there and have to listen to how these guys just botched the case, right? No real interest. Never even went in to 34 Fairview. Never. Not even like a month later. No. No interest in doing this. No curiosity about the weird, changing the basement floor. What is there? I don't know. Is there blood on the floor that they're afraid? DNA is tough to wash away. Blood, even with luminol, the blue light and all that stuff, and don't forget, these are cops who live there too. So they may know these things. They may know a little more than the average homeowner who's saying, how do I get rid of the blood or whatever. And it may not mean anything. Maybe they just, decided today's the day where I have an idea. Let's change the basement floor, fill the pool, get rid of the dog and sell the house. If you can't agree that that's weird in the context of what's happening here, doesn't prove anything, but it's weird. And you wonder, what if the cops did this as honest brokers, instead of saying, oh, these are the Alberts of Canton, so we can't do this. Go in the house. What if the DA says, you know what, why don't we get a warrant? They could get a warrant if they wanted one and see what's going on. Why don't we just look in every direction? And what I find really disturbing amongst probably all the other disturbing things, the most disturbing thing here is every real prosecutor knows, and we certainly, this is the way we did things back then in the Manhattan DA's office. When you're going to charge somebody and indict someone with a serious crime, there's really two things you have to consider. Number one, do I have evidence against them that will support what I'm doing? Obviously. But there's a second component to that, which is this. Am I satisfied that there's nobody else that could have done this and that there's not a plausible thing? Because I don't want to charge somebody just based on, well, they might have done it probably, but I don't really know. Let the jury decide, right? And that appears to be what they did here. How do you clear the Alberts and McCabe's and all of this stuff without ever investigating when there are plenty of breadcrumbs which at least lead or should have led a reasonable DA and a reasonable police investigation, whatever agency that was, to do that, to ask those questions. And if they clear them, fine. But if the only answer is we're clearing them because they told us, they pinky promised that, O'Keefe never came in the house, there's nothing to see here, go away. If that's your basis of clearing them, then, vote Morrissey out if you live in that county, because that's pathetic.
Definitely. Now, Mark, you're wearing pink tonight. People are asking if you're wearing pink for Karen Reed. Do you know about that?
You know what? I do know about it from online. I'm not doing it because of that, but that doesn't offend me in the least bit at all. I have great sympathy for her. I've represented people who have been in her circumstances. It's a nightmare. She appears to be handling it quite well, at least publicly. I'm sure privately it can be just excruciating. But, if it makes anyone who supports her feel better, I can't fathom.
It's a happy coincidence. I love
Yeah.
it.
It is. It is, but it doesn't offend me because I'm not,
Yeah.
I know like one of the reporters put on a
Yeah,
page.
was that ridiculous? They try to go after a
Over
reporter.
his
And
head,
he
yeah.
didn't do it on purpose either.
Right.
He just didn't know. Like he's just pink as the color people wear.
No, but I will tell you, and I'm certainly, not when I'm willing to debate this and have my mind changed. And, if there are intelligent lawyers who, feel differently, I think that would be a wonderful exchange to have, as opposed to, again, to fight under your weight class with the Wendy Murphy clowns of the world.
Exactly. If there's someone respectable, I would moderate it. I would love to moderate that. I would treat them well too, even on the other side. I would love.
I'm open to hearing it, but I got to tell you, I think she's probably factually innocent and is getting framed. And when I see these commentators laugh at that concept, it makes me laugh to say, you really have no idea. I mean, I've represented police officers. I've come after them, exposed perjury this week in a hearing. In another case of mine, it does happen. Not every witness tells the truth. I mean, I hate to tell you, but there are.
And that's the reason why there's like right now, I'm looking at the numbers. We're up over 1,000 just on YouTube right now.
Wow.
Like that doesn't usually happen. But the more people look into this, the more they know it. Like people aren't stupid. And that's the other thing. Like I've covered news and journalism for a long time. You look for cases like that. You can't find them. Like you just can't find them. This is something that is so different. So there is something to this. There is something going on. We got a really good question here. We got a few donations online. This one from John Barron, 1921, $25. Thank you so much, John. And on top of the donation, he got this great question. He says, Proctor is represented by an attorney that has previously filed a notice to intervene. If this attorney advises him to plead the fifth and never takes the stand, will a judge instruct the jury that he invoked the fifth?
Well,
Thanks.
Here's the thing. If I'm her attorneys, well, let's back up. If I'm representing Proctor, the client is him. And so that's your number one interest, right? You have to be loyal to your client and not have a conflict by worrying about anything else. So meaning if your client is Proctor personally, then you're not, as a lawyer, concerned on the outcome of the case, right? That's the DA's problem. If I'm aware that Proctor did what he did, went through her phone. Now, there's been a lot of talk about, the misogyny, looking for nude pictures and how disgusting that is. And I had that same case too, but that's the story for another day. That's terrible, obviously. But what lawyers are going to be much more concerned about, even though it's less perhaps offensive to most people because of the idea of violating my personal, literally my personal privacy. But if he searched her phone without a search warrant, then he clearly violated her Fourth Amendment right to be free from unlawful searches. That is, and by the way, that makes him virtually useless as a police officer going forward. Okay. When you intentionally violate someone's rights to look at their phone, to real prosecutors, he's done. Okay. He can't testify ever again. And then he may have looked at attorney-client privileged memos and whatever. That's terrible. And all the other things about him. And of course, the possible inconsistent sworn statements about whether, he knew the Alberts or not. Long story short, if he comes to me, my advice to him, probably understanding I don't know anything other than what I've heard, which is a big asterisk. I don't know what else there is or isn't. But if it's as bad as you think it is, my advice to him is you need to shut up and you take the fifth. So that leads to the next part. When he comes in with a lawyer who says, well, Your Honor, he's going to take the fifth. So, I want to invoke and, let's not bring him in. When you're her attorneys, you say, no. Get him in front of the jury.
Say it.
I intend to ask questions and let him say it in the presence of the jurors that he refuses to testify because if he, on the advice of counsel, on the grounds that he's afraid that he might incriminate himself. And if you can get away with this, and judges can do this differently, I would say, Judge, I want to do it question by question. For example, Judge, I'm going to ask him his name. If his name is Proctor, that's not incriminating.
Yeah.
And if he wants to do it and do it, I would do it to a point where finally I might say, for fear of putting the jury asleep, sir, if I were to ask you another 15 questions about this, am I going to get the same answer? Or are you going to, and at that point say, Judge, we're done with this guy. But I would drag him in.
Have you ever done that? Have you ever seen that happen?
Not to that extent. I mean, I've had witnesses who in the middle of an examination need a lawyer because it's going that way. He already has one. But there is no way that the jury is not going to know that this guy was subpoenaed as a defense witness and refuses to testify on this and this. And then, of course, they will sum up that he is a coward, he is a criminal, he is a misogynist, he is corrupt, and he and he's too gutless to look you in the eye and tell you what happened, which is very different from the defendant. I mean, you can't do this with the defendant, right? Except in Wendy world, which I know we're not talking about tonight. But in the real world of lawyers, a non-defendant doesn't have that kind of protection. The jury absolutely can conclude that this guy's not answering questions because the defense is right. He's corrupt. And the prosecution is going to say what? We're not calling the case investigator because, he has a constitutional right to not incriminate himself.
So there was a question in the comments that was asked during your discussion here, and Right On's asked, couldn't that be grounds for a mistrial considering he's the lead investigator? Would anything you just said that he may or may not do have an outcome on the trial going to a guilty or not guilty verdict?
Well, I think I think if Proctor refuses to testify, which I'm not suggesting he will or won't, I don't know. But if it turns out that he refuses to testify, then I got to tell you, there ought to be some serious conversations within the walls of the DA's office to say, well, this has been great. Now what? How are we going to deal with this? Because if you want, we talked about, jet fuel on the defense theory of corruption and frame up. If Proctor essentially becomes, the gutless coward in the eyes of the defense, who isn't, he's tough enough to say, I'm looking for nudes and, I hope she kills herself, but he's too gutless to answer my questions because, he is what he is. If you're the DA, how are you dealing with that? How are you defending the corruption theory? How are you even explaining this? And by the way, how are you explaining this and avoiding what Lally wanted to do in some of the videos we watched a couple of sessions ago, which is, Your Honor, they shouldn't even be allowed to get into what his problem is. Well, guess what? If he refuses to testify, if I'm the defense, I'm arguing, Judge, the jury's going to speculate what's going on. Now they ought to know why. Okay,
Exactly.
Why he won't. And I would argue that. I'm not sure I would argue it successfully, but I would certainly argue that, and I would certainly argue it publicly and loudly. And I think that if he does refuse to testify, if the DA has a shred of dignity at that point, then they would have to strongly considering what happened in the DeVecchio case, which was white flag, go home, drive home safely, and sorry. But and then Karen Reed can file her lawsuit and all of that. But putting that all aside, the only other analysis they could do if they wanted to go forward was if Proctor takes the fifth, how do they deal with that? How do they address that just in terms of damage control? But then the next question is, how do we continue the case? For example, if he's the witness who interviewed all of these other, alleged dirtbags who presumably could be impeached through Proctor, right? For example, I'm making this up. I'm not saying this is the testimony, but if they're going to ask McCabe a series of questions, they don't have to accept her answer. They may have evidence that she told Proctor something different. And if she denies that, the way you would impeach her is through Proctor and say, did you speak to McCabe on this date and da, 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 and didn't she tell you this, right? Well, what happens if Proctor takes the fifth and he doesn't want to talk about that? Now the jury is going to conclude that the defense is right. And what McCabe said is really what she told Proctor.
Exactly.
I mean, as a matter of common sense and for the love of God, like lawyer credibility and for Lally and Morrissey just to like wake up in the morning and look in the mirror and not look away. If he takes the fifth, dignity almost compels them to say, we're done.
Yeah,
I don't think they will necessarily, but if they have any dignity, they would.
Yeah, I don't think they do anymore. I think it's all gone. I think it's been taken away by Turtle Boy.
Yeah. So with that said, I was going to say, would it be in the defense's favor to, when they do call a witness, to call Michael Proctor right off the bat and just get right to it?
Yeah.
Well, I mean, again, you'll know if the DA doesn't call him what's happening. I mean, you'll know if they don't call him, this guy's probably taking the fifth. Because here's the thing. Let me back up. The DA so far has not demonstrated understanding the concept of credibility with the jury, and that part of that means you got to show them your cards, and there's bad evidence for them. There's bad witnesses, and you really should tell them that and be upfront, and then try to explain why it doesn't matter. And they seem to be taking the exact opposite approach, which is we're going to bury our head in the sand. We know they're going to get crossed, and the defense is going to expose all these things without recognizing the jury is going to look at the DA and say, why didn't you tell me this? Like, what else are you hiding from me? Why won't you just tell me what the problem is? And if they don't call Proctor and the defense calls him and then he takes the fifth,
it's over. I gotta think it's over.
And also picture the summation. Okay. We're the defense. We have no burden of proof. We have everything goes on them. And they don't even try to call the lead investigator who did all the work. Now, there are other practical concerns because I understand Proctor is also the critical witness with respect to Karen Reed's car, right? I mean, as I understand it, if I'm wrong, please correct me.
Nope. Proctor's involved in the car. He's involved in all the witnesses, interviews, mostly.
But the car,
everything.
I mean, if they don't have evidence to establish the chain of custody and the integrity, I mean, again, they're going to claim there's glass in the car and the taillights, other than the one piece that was found a week later from, Chief Wiggum or whatever his name is.
Yeah.
But all
Chief
the other
Berkey.
Right.
Yeah,
right.
Chief Wiggum. I like that one
Right.
though. Wiggum.
Yeah, sometimes I really should stop. But if Proctor is the guy who has to tell the jury that we can establish that the car is a good crime scene, meaning it was preserved and there was no chance for anyone to tamper with it. There was no chance for it to be corrupted. And we can establish that glass had to be in the taillight because no one else had access and did this and did that. Well, guess what? If the DA needs Proctor to do that and he refuses to testify, they're done. Moreover, it's my understanding the defense is going to attempt to establish, and they've discussed this, so I assume they wouldn't discuss it if they didn't have the goods to at least have a good faith basis to do so, that his documentation of when he got access to that car doesn't exactly match up with real life and video. And nobody else can explain that but him. So Proctor, Proctor and the DA are like tied together, wrapped up in a chain.
Yeah.
And if one of them goes over the cliff,
They both.
sorry.
It's so
like a locomotive.
But it seems like the DA wants to almost sever ties. It's funny. This is going to be.
Oh, no. They don't get to sever ties. Yeah. And you can be sure that these lawyers who clearly know what they're doing are going to wrap Proctor and these DAs around each other every single chance they get and never let anyone forget about it.
Yeah.
By the way, I understand from something else, that Proctor is the chief investigator and this other lunatic, the Walsh guy who Googled, how do I, cut up my wife? That case.
Yes. Yeah. Yeah.
Yeah.
I remember talking to the New York Post about that case when that came up. But when somebody told me he happens to be the lead
He
investigator in
is.
that case, my God, I can only hope and pray that he didn't destroy that case because of his conduct here. Because you want to talk about a real horrible impact because this guy's such a terrible person that, you don't want obviously some guy who did what Walsh allegedly did to get away with that, assuming he did it. I mean, I'm not,
Yeah.
but
It sure looks like it. I mean, his text. It's funny
Yeah.
how data
Exactly.
they accept all the data in Walsh's case, but not the Karen Reed case.
See
I
how
want
that
to ask.
works, huh?
Yeah,
Funny,
I want
right?
to ask you a question that came in from another attorney. He's a state attorney, Brian Barea. He said, "Is there any what's a possibility of the prosecution doing this kind of drip, even though Lally's boring, to bring up every single cop, every firefighter, every EMT, and just kind of drip every day to kind of win this jury over that she said it."
Well, if they're going to testify to corroborate from their perspective that she said it, at this point, I think they have no choice but to do that. But if you think you're going to win the jury over in a case like this, where, a dullard is trying the case and putting people to sleep, and just like methodically doing all of this, I mean, I think that's not going to win anyone over. But, if they're trying to justify that we believe that she confessed and that, this was the auto accident that we're talking about, then at that point, I would say they have no choice because, I mean, look, what do they have? We've already gone through Proctor. Okay. They have a medical examiner who is going to say, I don't even know, what the manner of death is, but there are all the medical examiner is not going to be able to say that those injuries to O'Keefe's hands and face are not necessarily inconsistent with having a fight. Okay. He's not going to be able to say that giant gash on the back of O'Keefe's head is not inconsistent with being hit with, like somebody mentioned, weight equipment or something like that. Everything is very linear too. It's very like that's a very straight thing that feels like an object. And I don't think anyone's going to say that object was, her taillight. That can't be, right. The thing on the back of his head can't be the taillight. So what else do they have other than, if she said she did it, she must, why would she say, I mean, the argument would be she came out right away and told the cops, which also begs another question, not to go back to his terrible opening, but why didn't he come out in his opening and just say right out of the gate, I hit him. Those were the words of Karen Reed on January 29th, 2022. The
Right.
minute she saw a police officer, while she was under the emotional strain, when people are more likely to be honest. I mean, that's the whole theory in life.
Yeah.
That people, when
Right.
they're freaking out, are less likely to think up a lie and this and that. And instead, he comes out with and says, so, I'm going to get two chances to talk to you. One of them is now and then later. And then we're going to call witness A, B, and C. And I don't know why they just didn't do this in a different way. But the bottom line is, at this point, if they have any other witness, no matter how pathetic, who's going to say that I heard her say I hit him, yeah, I would call them, because what else do they have?
Awesome. We also have another guest in the green room that we want to bring up. She's also she's recently passed, I believe, the bar exam. She's
Yeah.
a new lawyer, and I think she's been on the show in the past. She's been following this too, so I thought it'd be a good show to bring her up as well tonight. She might have some questions for you, Attorney Bederow.
Sure.
And I think she's been listening here, so let's see what she's got to say. Hey, Lauren DeLaguna, how you doing?
Hi, I'm great. How are you?
Awesome.
Congratulations on the bar.
Thank you. Yeah, I just swore in Arizona. I'm waiting on my bar card, and I passed in Florida, and so just getting through character and fitness. And
I went to college in Arizona State. See,
Oh, nice. Very awesome. Very cool. Very cool. Yeah. Well, thank you for having me.
Thank you for being here. Were you listening to any of our discussion earlier? I don't know how long you were there for.
I was listening for the last like 20 minutes or so.
Oh, really? Awesome.
Yeah.
So,
Um,
yeah, go ahead.
No, I mean, it's hard not to continue to circle back on how piss poor that opening argument is. His opening statements were by the by the Commonwealth, just because they were so shockingly atrocious. They were so boring. And if he genuinely believed certain facts, such as if he genuinely believed he could show the jury and convince the jury that she said at the scene, I did it, he would have included that in his opening statements. But the problem is with your opening statements, if you promise something to the jury and they don't get exactly what you promise, then you've lost the jury. They're just going to be sitting there waiting. And then if you're doing closing arguments and you haven't done everything that you've promised in your opening arguments, you're going to lose. So there's a lot of reasons that he gave a boring opening argument without any of those key interesting details, because I don't think he's confident that he'll be able to actually show those key details, as we saw when on the second day of trial and he was talking to the first responders, and two of the three, I mean, didn't had writings the day of the incident and didn't have that statement in their writings. And then third one didn't even have a writing. The
Right.
firefighter didn't
I'm
even
glad you
have
brought
it in
that up.
writing.
They changed the written statement was different than what they were saying in court. That's such a good point.
The one guy, Saroff, was terrible. Yeah, but just to kind of follow up on that, I mean, with the openings, yeah, I mean, this guy has no confidence in anything. And again, he's projecting to the jury that he's just a complete dullard. And, he's white knuckling the podium, which is one of those things in trial practice. You want to get out the ruler and smack them. I mean, I'm not saying you have to be one of those guys who's going to walk around the courtroom and do it without notes. People might do things differently. Everyone's got different skill levels, but why don't you put the notepad away or put it to the side, let go of the podium, put the pen down, and tell the jury what you're going to prove and what's going on. But while doing that, juries need to be, steered to what they're going to do. And every single juror knew about this case. It's one of those rare things. Not every case is like that. Not every case has publicity or whatnot. They need to be led and steered. And, a trial is it's a scrum between the parties. Who's going to grab the jury and pull them like in a tug of rope? Come with me. Okay. And usually, at least the party who does that and wins that tug of war in the beginning, usually it's after an effort by both. Okay. And the worst part is the DA didn't even try. They just yielded right out of the gate. I mean, to come out and say, I'm going to talk to you twice, and so-and-so is going to testify and say this. So-and-so. Honestly, in an opening statement, I don't need to hear 57 names of witnesses that I'm not going to remember anyway right now. What I need to hear is, we say she's guilty of murder, and here's why. And here's what we're going to prove. Not through 87 different witnesses, but she said this, and her car taillight was here, and there was da-da-da here, and you're going to learn that there's no other way here, and this and that. And they just didn't even try. And then I agree that what they can't do is make promises and write checks that you can't cash, because that will blow up in your face. But whether they felt strong enough or not in the opening to do it, I go back to these, first couple of witnesses. These people in a normal case, if you think they're going to come out and say she confessed, in the normal case, the defense is going to be thinking, this is bad. This is trouble. I mean, right out of the gate, I'm getting punched in the mouth. They already, why would she confess that if she didn't do it? And instead, what they're wondering is, why didn't this dope remember such an important statement the day it happened? Why did it take several months? Why did it take Lally and a grand jury? And he didn't even tell Proctor the first time, which is remarkable given what's going on here. And then you follow that up with a guy with I hit him, I hit him, I hit him, I hit him. But I'm also highly confident in the puffy jacket and all the other evidence. And I'm telling you, it's just blatant non-preparation of a witness, because if you prep the EMT and he says to the DA initially, oh yeah, he was wearing a jacket in their office, and then you show him the pictures, something like that. I'm not even going to suggest that that's Brady material, exculpatory material that they're obligated to say. But are you sure? Let me show you these pictures. Are you sure that's what he was wearing? Oh, you're right. I remember. But they do it in the office so that when he testifies, he's not gratuitously offering puffy jackets. Lally knows there's no, this is what's so pathetic.
Yeah.
Knows
Lally knows.
direct examination, there is no puffy jacket. And why is this witness talking about a puffy jacket? Why didn't I prep him? Why didn't I show him pictures of O'Keefe? Why didn't I show him pictures of the clothes? But he did show him pictures, just the wrong pictures. It's beyond comprehension. It really-
Natel didn't even recognize the image of the clothing that John O'Keefe was wearing. It seemed totally foreign to him. It was
Yep.
quite interesting, quite notable.
Yep.
It's crazy.
You know, another
This-
thing I wanted to say too is that Natel was also unable to confirm any laceration on the back of John O'Keefe's head. If I'm not mistaken, he was unable to confirm that yesterday. Alan Jackson asked that specifically.
Yeah, he
Did you
didn't
see
say
any
it.
laceration? Well, I don't remember, or I don't
I
know. He
don't,
might have said.
I don't put too much weight in that, in the sense
Okay.
that, you know, he loaded him onto the thing. They put him in the ambulance. He did a little search. I mean, you could argue if he's there and he's telling us I have to undress him and I need to look for every little possible injury, you could argue that if he didn't see that and it's obviously there, that maybe he's not as reliable as he purports to be, and that sort of thing. But to me, it's kind of a small thing, because when it comes time to sum up on Natel, all you have to do is talk about, you know, the phantom puffy coat, which again, this is what's so crazy. He volunteered.
Right.
It wasn't like he was
yeah,
pressed.
he wasn't even asked.
He had this, and he wasn't just agreeing with the lawyer to like say, leave me alone. He volunteered it more than
Correct.
once. You're
Lauren, you're
silent.
on mute.
Lauren speaking. You're on mute, Lauren.
You're
still on mute.
muted. Yeah.
It happens to me all the time. She's working on that.
Speak
Go
for
ahead, Lauren.
5 minutes now. I'm like, well, I can't even hear me.
Hmm.
The reason that the puffy jacket is particularly interesting as well is because the reason that he gave for like giving that information is, oh, we already kind of felt rigor mortis. Everything was stiff. His arms were stiff. That's why. And we noticed this when we had to take off the jacket. Typically, we just cut through clothing, but this time we had to take off the jacket because puffy jackets we don't cut through because it creates a mess. So the whole reason that he offered the puffy jacket in the first place was so that he could give more detail about the rigor mortis, which would go to the prosecution theory that he was in the snow for such a prolonged period of time that he would have been that stiff and that cold that it would have made sense, and that he was hit when Karen Reed allegedly hit him. However, that's just not true. They never cut through a puffy jacket. They would have never experienced that feeling of knowing that his limbs were stiff. They would have never had that issue. Like they would have just cut through all of the clothing. So I'm wondering, are these like implanted memories? Is he switching to different deceased people who died in the snow? Because he has been working as a firefighter.
That's right.
He said EMT since when he was in high school, and firefighter before he was 21. So, I mean, there's a lot of, you know, patience that he's had in his life, especially in the cold. I don't know. But then that, once again, that goes back to the deep lack of preparation on the Commonwealth side. And it's almost, it's shocking. Like I talked to an attorney who's trying to stay very neutral in this case. This weekend, I had the pleasure of getting lunch with them. They're trying to stay neutral in this case. And they're like, but I just can't get over how poorly the prosecution has done everything. Like, I want to stay neutral. I want to hear the evidence from both sides. But when one side comes completely unprepared, I don't feel like I'm even getting a fair trial on behalf of the state.
And that's when they have the ball too. I mean, this is right. This is when they should be destroying it.
I think what Lauren said actually is a very good point about the context of the puffy jacket. That's an excellent point, because it's not like a gratuitous, what he was wearing this as part of a general narrative. He cited that for a very specific reason, talking about what he was trying to do, which again, if true, makes sense and whatnot. And it does lend itself to a very good argument in summation that this is a guy who, does this for years and years and may very well be mixing up people, which is, it happens. Again, I don't think he came off as a corrupt individual. I think he came off as somebody who screwed the pooch on what he remembered. And when he was confronted, he ate it. I mean, he rolled right over, and and that happens with inexperience.
Alan Jackson called him on that too. If you can't remember this, and that, then how can you specifically remember that she said, "I hit him, I hit him, I hit him"? And I'm glad Alan Jackson.
And that was such a good point. It was such a good point. How can you?
They will
especially because they talked about how the firefighters frequently get together to discuss this case. So you're in that firehouse for 2 years. And for one of those years, she basically had no public defense. So everybody was anti-Karen at that point. And you just have a bunch of people who are pro-cop loving, which I used to be pretty strong, hard back the blue. You get a bunch of firefighters in a firehouse constantly talking about the Karen case. Oh, I can't believe she hit him with the car. You might get implanted memory, like false memories of her saying, oh yeah, I was on that case. Oh yeah, I think maybe she did say something about hitting him. Like, it's not necessarily that he needs to be involved in any conspiracy, but he absolutely doesn't have the memory to go back. And then a further part that Jackson went on, if you heard someone saying, I hit him in a homicide case, don't you think it would be important to tell an investigator? Why didn't you write it down? Why didn't you make a note? Why didn't you tell anyone that you heard the alleged perpetrator of a murder commit to the murder? Isn't that relatively important?
Yeah,
it is. And
even if he didn't do it that day, that morning, then why not after he might have learned eventually that John O'Keefe had, died? Why not, the next day even?
Exactly.
At the end of the day, this is why they're screwed, frankly. These should have been powerful witnesses for them. But in order for the DA to win, they needed to be unassailable, unimpeachable, strong, credible witnesses that she said this. And then, of course, even that wouldn't be enough. It would make a jury wonder. It would make a deliberation longer. Well, why would she say that? But they can be easily swept aside, because when you factor in everything else that's going to come out and a jury says, yeah, but what about these statements? It lends, yeah, but he didn't remember the code, and so he's not reliable, and he didn't do this. And with the cop, he didn't write it down. And you know what? That deliberative process and justifying it takes about 30 seconds. And then you say burden of proof. And again, if you're trying to make these statements compelling, look what we're doing. We're trying to give the DA an explanation, but they're fighting uphill. All of the common sense at least lends, again, there's that word plausible. It's plausible that Sarif was fed what he said because they told him to say it, or because they told him that's what McCabe remembered. And Proctor said, come on, he's a cop. Is that plausible in light of the way he did no investigation and somehow miraculously remembered a statement in the grand jury? Yeah, I'd say that's plausible. Doesn't mean it happened. And the other guy, is it plausible that he mixed this up with another case, or he just didn't hear her say, and all the crazy hubbub because he's focused on, giving oxygen to O'Keefe, that he might have missed something? She's hysterical. Is it plausible that he misheard and it didn't happen? And in any event, he didn't even know the clothes he was wearing. At that point, these people are not unassailable in terms of their credibility. It doesn't mean they're liars. It doesn't mean they're bad people. But from the DA's perspective, the needle should be at their high point right now. If you do this, how are they doing?
Right.
How are they doing? And I didn't think it would be possible to be any lower after their opening, but they are, because these are their strong witnesses and they're useless.
Right.
I know. They've struck out.
I hear so many defendants complain, oh, well, the state gets to go first. They get to make their argument first. So it's hard to win because you talked about that tug of war earlier. When you get to make your case first, you get to have your opening statement first, then you get to question your witnesses that are supposed to be on your side first to really prove your case and outline your case first. Then you're already winning in that tug of war a little bit. And so it's always like an uphill battle for defense to come back and be like, okay, you already see their side, try to see our side now.
Yeah.
And they're not, and the state it's their turn. They're supposed to be winning this tug of war right now. It's supposed to be on their side. It's not on their side even a little bit. This pendulum hasn't come even a little bit to their side, to such an embarrassing extent that the first two witnesses, the defense didn't even have to cross-examine. That's embarrassing.
That's exactly right.
When you don't cross-examine a witness, that's a really good indication that the opposing party didn't elicit any information damning to your side or damaging to your side. So they've accomplished nothing so far. If anything, they've hurt their case. I mean, one of their witnesses even said, oh, he had scratches on his arm and made this movement. I feel bad, honestly, for Lally. It's embarrassing watching him. I can't imagine. I don't know why they didn't have anyone help him, because I thought with, these pretrial conferences, I thought he had done pretty lousy, but I was like, okay, he's just not performing because there's no jury there. He's just talking to a sympathetic judge that, so he has no reason to be entertaining or to make really great points. He just has to get the bare minimum across, especially if they're not going to check any of his work, because I've gone back and I've read through some of what he's given to the judge. And when he cites cases, I honestly don't believe he reads the cases that he's citing. When he's saying, oh, this case supports my opinion, I don't think he's actually rating those cases. As we saw when he accidentally quoted, what was it, Yanetti's case that he quoted as being as his side, that he totally misconstrued the entire purpose of. So it's just really embarrassing. It's hard to watch, honestly.
It's crazy. And Olivia Nile just made a comment about all these witnesses talked to Michael Proctor. So, I mean, that it seems like their stories changed too after they talked to him. So that's another thing that I think the defense will
trying to establish
go after.
Of course.
We had a good question come in. Cam just sent $19.99. Thank you so much, Cam, for the donation. He said, just a question, as a law school student, and this is a good question because this came up with another attorney on another show. It's basically about the judge not allowing the basis for objections when she sustains or overrules. How does the defense know on what basis she's relying on?
Okay, so
yeah,
the way this works is, I mean, each judge has their own courtroom rules and procedure. Most or a lot of judges will say, I don't want to hear it. I don't want to hear you speaking and in front of the jury. Essentially, judge, this is hearsay. They get concerned that you're poisoning. So a lot of judges will say, unless I ask for it, I don't want to hear it. And it does lend the question, well, what happens if, the defense needs to know? You have to preserve the record. It's a couple things. The first thing is most objections are not regarding subject matter that, a leading question, for example, or something like that. That's never going to lead to any issue. But if it relates to an entire line of questioning or something important, and, she says overruled or sustained, move on, then what the defense simply would have to do is ask to approach outside the presence of the jury and say, I need to be heard. And we can do it at the bench. We can kick the jury out or do it after court, but I need to make a record because it's got to be on the record. If it's not on the record by the court reporter, then it can't be appealed. If it doesn't exist if it's not on the record. So if you have a situation where she's making, rulings that she doesn't want to talk, then you do it privately. You saw this earlier yesterday when they were trying to cross-examine the EMT about some of the injuries. And I can tell you exactly what was going on there. The objections, which were repeatedly sustained, and Jackson kept trying, and finally she says, come up here. you know, and I'm sure what she's saying is you haven't laid any foundation that this guy has the medical training, you know, in order to even assess whether he has enough knowledge to even say that, I guess what they call it, the egg, the blood vessel clot or whatever.
What caused that? If he has the expertise to determine it.
And I'm sure she told him, why don't you see if he's even qualified? And then he did. And then what happened? He asked the questions and he got it out. But the way it would be handled if she does it her way is you just have to do it outside the presence of the jury on the record, though. That's critical.
I do find that obnoxious, though. It would be nice for them to say objection lacks foundation. Objection calls for speculation.
The reason why, though, that a lot of judges won't allow that, I agree with you. It's a waste of time. It makes the process. But some judges don't want is when you do that, you're essentially tipping the jury like I'm right and here's why. And if the judge were to rule against you, you know, you in theory, you don't want the jurors making their own decisions or following someone else's belief other than the judge. It also may very well be, you know, a judge who may lack confidence in legal knowledge may be more inclined to say, I don't want to hear it. So because if I just say overruled or sustained and say nothing else, you can't really go at me and challenge me on the law. On the other hand, you know, objection, hearsay. Why is it hearsay? Now we're having a discussion
about hearsay.
That maybe, you know, the judge, I'm not saying it's the case with her, but may not be equipped, because you'd be surprised how many judges don't know much about the law.
Someone's talking about the huffing and puffing
You know,
the judge makes. Could that be a grounds for appeals?
I'm going to tell you something. We've talked about her before, and I've gotten a little slack or heat from some people.
Me too, but
not being critical enough for her. I'm going to go the other way on this one. I've been listening to the huffing and puffing, and again, there's no question. It does appear to be defense oriented. I agree. Her objections sound a little more, you know, annoyed, you know, when the defense is doing it. This whole idea of where she did call him up to the bench when he was, you know, asking questions that, you know, in all fairness, he had not established the foundation. On the other hand, you know, she does let the defense do what they want if Lally doesn't object. In my view, there were a lot of questions that Jackson asked that probably were improper in terms of format, not substance matter, but there's a way to refresh recollection or attempt to impeach a witness with a prior inconsistent statement. But if Lally is a potted plant, she's not interrupting on her own for the most part and saying, what are you doing? You can't do that, which some judges would do. But the huffing and puffing is not an appellate issue for a simple reason. It's not going to be in the record, right? Unless the defense, and I would strongly recommend they not do this, outside the presence of the jury says, Your Honor, we want to make a record. We can't help but notice that you're huffing and puffing and, you know, rolling your eyes at us. I mean, they're winning. Okay.
So why do it?
The judge is not the real enemy here.
Exactly.
She's not going to prevent an acquittal. I don't think, you know, picking a fight with her over her habit of huffing and puffing.
Take the win. Yeah. Like
you don't want that in the press, and she gets pissed off and
exactly.
Whatnot. But I do notice it, and I do agree with people. It's a little.
I just wish she had a mute button. I feel like she's got issues, like she can't control herself or something. And like we have a mute button. Sometimes we forget to turn it off, turn it back on, you know, but I don't know. I think she needs a mute button.
Yeah.
I hope I never come off as, like, if I were ever a judge, I would never want to come off as blatantly biased as she does. I think that is horrible. Everybody sees it too. And I don't think she's not really trying to hide it. And that's really unfortunate. I was surprised that she gave the defense, like she sided with the defense on any objections, but the jury must see that she's, I don't know. If you know nothing about the case and you're sitting on the jury, do you think you would recognize that she's biased towards the state?
Yeah.
I don't know. I mean, look, she seems like a dour, very plain, limited personality,
Yeah.
all of that.
I like this comment. Perpetual exasperation. That's just
Yes.
basically how she seems in life.
That is a perfect that's exactly what I wanted to say. I would never say it that articulately, but that is, I mean, she just seems, this has nothing to do with her judging skills.
It's her personality.
She seems kind of like an unhappy, like I have to come here every day and I'm dealing with this case. And you know what? This was always going to be a big case, but then, it got blown up by, the other guy who they had to take to another judge, right? And made this a mess. And now I'm stuck with this crazy stuff. But, as far as her rulings, we've talked about this before. I'm not offended by the rulings.
Yeah.
I don't like the.
Exactly.
I did.
I don't
hear
like
it.
listening to it. It's so
No.
true. It's true. Like, I agree with you 100%, Mark, because I feel like I'm pleasantly surprised on how she's ruling. Like, when she didn't interrupt Yannetti on his open, I was like, okay, we're gonna be okay.
That
Like
was a
what
big step
Mark
for
has
her.
been saying is
That
correct.
was a big step for her.
But I've been telling you, one of the things that she seems to be doing, and she did it again today, and I think this is really important. You have to defend yourself in the courtroom and defend your party, okay? And Lally has the burden of, the Commonwealth of Massachusetts on his shoulders, and he is their mouthpiece. And if he's not going to stand up on their behalf and object, well, guess what? For the most part, she's letting them go. And the best example is the opening statement. I mean, she basically said, I don't want to hear about third-party culprits unless there's evidence that comes out at trial. And the defense said, okay, we know, and then essentially argued third-party culprit, and he sat there like a potted plant because normally it's bad form to object during an opening or closing. Normally, because it can look weak, it can look like you're just trying to prevent each side from doing what they want to do, but there are times that you do it. And this kid needs to wake up because from their perspective, that was the time to do it because they were totally getting into areas that the judge, whether you agree or disagree, said were off limits. So what it also tells me is that he can't handle the pressure and the publicity angle. And he's outclassed, I think, in their legal skills and everything else, obviously. But I think there's so much attention with the TV cameras, the craziness outside the courtroom, that at some point he's afraid of being ridiculed even more. And if you object and it doesn't go your way in an opening statement, he didn't do it. But that would have been the time to do it.
What's your opinion on, as like a defense attorney, what's your opinion on the defense? Would you consider that a violation of the motion in limine, their opening statement? And do you think that that was a decent risk that they made in just hoping that Lally wouldn't object and hoping that Judge Bev wouldn't interrupt?
I don't know. I mean, I think they towed the line. I mean, one could argue that did they go over? Maybe. I mean, obviously, when you argue that this was a frame job, that almost implies that she didn't do it. And we have based on the other part of the opening argument, opening statement's not supposed to be argument, which is another thing he could have objected to. Yannetti was arguing, but whatever. That may be more, you could object to that. But, he was talking about the people who clearly he was involved in, must be responsible for what happened here. But I mean, I think they towed the line. So I don't think they did anything that was sanctionable or anything other than potentially we get an objection. She says, I told you don't do this, don't do it. And they say, yes, Your Honor. And they just, stick to the cover up in generic terms. So did they make a calculated risk? Maybe. But, you also learn from what's happening. And if he's not going to object, as long as you're not being unethical, they should push the line as far as they can go.
That's true.
I mean, obviously you can't do things that violate, ethical rules or the rules of the court. But, again, as part of this tug of war, I mean, it's like there's no resistance.
I
Yeah.
don't know how you don't. Lally has an assistant, right? Like Lally has help, some help
I'm
somewhere.
glad I'm glad you just said that, because I thought, and I even made a note when I listened to this today, at one point I thought a female voice
Yes, me
made
too.
an objection.
Objected.
And I almost fell out of my chair. Now I can't see if he has someone else there, but I will tell you this. One thing that never, ever, ever should happen in a trial, when there are multiple lawyers for any particular side, one lawyer has a witness, for better or for worse. Okay. You direct them, you defend them on a cross-examination if there are objections or whatever. And I swear to God, I heard a female lawyer object to part of Jackson's cross-examination. And if they are literally tag teaming examinations, then this shit show is even bigger than you ever thought. Because
that's Laura McLaughlin.
That should never happen, because she's probably doing that because she's sitting there saying, why aren't you objecting? But even then, she shouldn't be doing that. She should be elbowing him, taking his pulse again, waking him up, give him some coffee.
Give him some coffee. Give him,
wake up, man.
Yeah.
It was weird though, because her objection was overruled. So she didn't even, like, if it was such an important objection, it would have been a very, very, very legitimate one that would have been sustained. But yeah, so I just don't understand how the Commonwealth isn't supporting Lally significantly more, as they saw him struggle through each and every one of the pretrial hearings. You would think they would have gone in, they would have prepped him, they would have helped him prep witnesses, they would have given him more support, but the Commonwealth has really just kind of fed him to the wolves. They're like, hey, here's an innocent woman we're charging with murder. It's your job to convince a jury. Good luck.
Is it possible that they're, pardon my French, scared shitless of the federal investigation at this point? The Commonwealth and all of them are just phoning it in?
Yes and no. I mean, are they generically, should they be scared? I mean, I don't know what the status of the federal investigation is, but based on all these weird facts, I mean, you can understand why the feds would be, the investigators are investigating the other investigators. I mean, there are just too many weird things going on here, and it goes beyond Proctor. So, yeah, I mean, I would be scared, wouldn't you? But on the other hand, the way to handle that and the remedy is not to say, the best way for me to, not piss off the feds and make sure I don't get in trouble is to continue with my wrongful prosecution and continue to hopefully convict what is probably a factually innocent defendant of murder and have her sentenced to prison for the rest of her life. That's not a great way, I would think, to warm yourself up to the feds. Now, look, it may very well be that these people in the DA's office believe she's guilty because they just are incompetent, dumb, corrupt, any number of things. But the problem is, and we talked about this earlier, and I would harp on this again and again and again, you don't indict someone and charge them with a crime like this, even if you have, what you think is probable cause based on the statements in the grand jury that now we know are not very reliable, unless you're satisfied. We're pretty confident it's got to be her. Like, there's no other person it could be. You don't try someone for murder when you say, I think it's her, but I don't know about these people. And the thing that is stunning, it's bad enough they never considered 34 Fairview as a crime scene in the beginning, right? We know that in those critical first days and weeks. But you know what? In the last 2.5 years, they never considered it then either. And that's crazy. And even if they don't think there's anything there, dot I's, cross T's, be fair, be thorough. And the answer isn't, well, let me just interview them. And if they say that, O'Keefe never came in the house, then, everyone's good, let's go home. You've got to do more. You ask questions. Why did you change your basement floor? I mean, all kidding aside, police officers live in that house. They know how crime scenes work. And if you know anything about forensic science in these cases, you can scrub up blood all you want. That's not going to get rid of DNA. It's not. you may not be able to get rid of it unless you basically throw acid or bleach or something else, or change the floor. Now, maybe the wife wanted a new floor and said for 6 years, I want to do it then. I don't know, but these are all little things in the
And got rid of the dog.
all of that.
Yeah,
The
poor
dog,
Chloe.
pool, absolutely.
Sold the house.
Chloe. I want to
Or
know where
how
that
about
dog
I
is.
also found it, speaking of 34 Fairview, it is wild that Lally didn't prep the officer, Sarah specifically, on the issues involving the report that showed the incorrect timing of when the police officers showed up, which
once
showed
again,
the incorrect address. And then he was like, okay, so everything is correct on this page except for the time. How has the police officer never even watched court TV before? If an attorney is asking you that, then that means there's something else on the page that is wrong. You should at least skim it. How do you not know that it's 34 Fairview and then look at the sheet and then see 32 and go, oh, right, this is also an issue, but the houses were like, come up with an excuse then and there, but to just be like, nope, everything else is correct. Oh, what about this though? Oh, okay, that also isn't correct.
the problem with that is twofold, and it again exemplifies how flawed they are, and how, frankly, as I said, they're trying to punch up in their weight class. They're not up to this. Obviously, Saraf, who I would suggest has never seen any court TV or anything similar, but obviously Saraf was not familiar with the contents of that document on cross. That was clear. The question that I would ask before that, and that's a very good question, is, given what the defense is, they have not been bashful. They are not hiding the ball. Okay. Where they're going, that this is, corruption and frame jobs and all that. Okay. So the defense opens on that nothing bad can ever happen at 34 Fairview because that's the Alberts of Canton live there. And, we heard from Proctor's text messages. Don't worry. He's good. He's a cop. Knowing all that, how do you, and knowing, or maybe he didn't know, I don't know, but that the dispatch moves this crime scene away from the Alberts to some patsy neighbor. And then the arrival times, I don't even know what that's all about. Put that aside. The address is the real big one. That is something that we talked about earlier. When you deflate the balloon, get it out there on direct and show them and say, is that accurate? No. Do you understand? Do you have any understanding as to why that would be? No, I don't prepare that document. I don't know. What I'm telling you is I arrived at this time. This is when this guy arrived, and you've deflated it. And then you know what happens on cross? About 30%. Okay. So you told us on direct, it's the wrong scene. And he says, yeah. And you know what? That's it. But it's like they don't prepare. It's
Lally didn't prepare because it was Lally's job to do it on direct, and to wait to have to do it on redirect after cross. So your witness just got annihilated on cross. So now you have to redirect. Yeah. That's horrible for you. I mean, your first two witnesses didn't even get crossed because you did such a poor job. And now you have to redirect because your next witness got completely annihilated. That's not a good look. And exactly what you just said, he could have avoided all of that if he was just prepared. If Lally had read the document before the hearing, and if Lally noticed those errors in the document, then none of that cross-examine would have been as powerful as it was.
Yeah, it's a document, and then we can move on from this point. It's a document you show the witness in trial prep, and you say, what is this? What is the explanation? Let's talk about it. And what the cop would say is, I don't have an explanation. I'm the cop at the scene. I'm not the dispatch guy, right? I'm the wrong witness for that. And which is, another thing, when the lawyers on cross are asking him to draw conclusions from documents that he didn't create, it wouldn't be so bad if once in a while if Lally stood up and said, Judge, how the hell does he know? Privately, because you can't say that in her court. I understand. But they're letting them push the envelope. They're getting away with it, and they're establishing what they need to establish. And, it's not a fair fight.
Now, tomorrow, court is 9 a.m. to 1 p.m. And then Friday, apparently, reports are they're going to go to 34 Fairview. They're going to go to the house, actually. The jury is. So it looks like we have one more day of testimony this week. What do you expect tomorrow? What do you think is going to happen tomorrow when these cops? Is Lally going to get any better? You think he's going to be any?
No, I mean,
Okay.
let's be honest. He is what he is. And again, I don't want to turn this into like just keep pounding this guy, but whatever. We're calling it as we see it, and he's not good. So it is what it is. But he's been handling this case now for a couple of years. We've seen his oral arguments in the past. We've seen him do his opening. We've seen him do these direct examinations. He is what he is. You're getting what you're going to get. And what's going to be real fascinating is most prosecutors don't know how to cross-examine because they don't do it that often. And when the defense calls their witnesses, including the experts, the reconstruction people, you're going to get a lot of hamada, notebooks flipping, crinkling, frantic scribbling on the notepad. And,
I think he's going to try to avoid cross-examining the experts, like particularly the expert that's going to talk about the Google search and what time that came in. And he's going to just try to use his own experts to explain why it occurred at what he thinks is like 6:27. Because the problem is you don't want to ask a question that you don't know the answer to. And he's clearly not preparing even the basic stuff, like the facts of the case and what John was wearing on that day. So how is he going to prepare enough to really understand that technological structure to be prepared enough in order to cross-examine an expert?
Here's how, again, with the caveat that he's probably not going to, right? Based on what you just said. If he's smart, you would do this. They have experts. Like, let's talk about the phone, the Google stuff. Okay. The defense has reports prepared by their expert. You show it to your expert and you say, can you explain this to me in English? Is this good, bad? What am I dealing with? And then you say, how am I cross-examining him? You get educated by your own expert. And, presumably your own expert is going to say, well, this is airtight or this is a problem. And, you do the best you can. You're right. I mean, he's not going to have the scientific knowledge to understand any of this, but you attempt to use your own. But what they can't do, the problem in just ignoring the defense expert is this. If the experts, for lack of a better term, cancel each other out, which I don't think they will, by the way, but if they do, and it becomes a push or it becomes, I don't know, moves the needle to the defense.
Yeah.
Right?
Gee, Mr. Hand,
goes to
I
defense.
don't know.
Yeah.
Yeah, right.
In order to do what you just said,
Having
in
some
order
food
to
and learning about Cuba. Right?
And
That's right.
what does it look like to the jury if he doesn't cross their experts? I mean, that looks really weak, doesn't it?
It does look weak.
And that's a good point.
I
You
mean,
may do that.
I mean, look, it doesn't have to be long, but if there are some holes or things, or, I mean, look, is it going to be the canned cheesy cross that basically, you're a hired gun and this and that, which, again, we see in Wendy World is what the problem is. But the reality is, and they're not going to be able to say this. This is where it gets really dicey that you don't, break the judge's rules. So if Lally comes after, like, say, the reconstruction experts, which are the real problem experts, right? When they come in and they say, guess what? No way, like, this can't be. And then two other ones come in and say, guess what? If you attempted to go after them for being unqualified or, for lack of a better term, a paid assassin by the defense, and you'll say anything, you better be real careful, because the reality is they were hired by the federal government to do an independent analysis without having an opinion to tell us, what do we think?
Yeah.
And if he opens the door, now, again, they're never going to be able to say, a federal investigation, but the reality is that these experts testify on behalf of the government. I mean, the feds wouldn't be using them if they weren't credible. I mean, they could theoretically be witnesses against anyone who was charged in any kind of corruption case or falsifying evidence or whatnot.
So they got to be good.
That's right.
You got to be credible because
Yes.
they want to put people in jail with them.
That's right.
This
Yeah.
is
What
going to
you
be
said-
so interesting. Go ahead.
What you
sorry.
said earlier about, well, when you like for the Google search experts, what you would do is you would take the defense their experts written report, and you would take it to your expert and ask for their opinion on it. Wouldn't you have to prep the witnesses in order to do that? And based off what we've seen in this trial, it doesn't appear like Lally's doing even the basic prep with his witnesses. So do you even think Lally has done that basic prep work? Do you think he even sat down with his own expert and reviewed what the defense expert is going to say? Or do you think he's just going to apparently wing it, which is what it seems like he's been doing this entire trial?
Yeah.
I don't know, obviously, what, I mean, I'd hope, again, not like I'm hoping for him to establish what I think would be a miscarriage of justice conviction, but just as a lawyer and former prosecutor with, sympathy to the profession, not this. I mean, this is what these people are awful, what they're doing. I think they're unprofessional, and there should have never been an indictment, but just like professional to professional, I hope for his sake, my God, that if there are a few witnesses that you would at least prepare, it would be those. But on the other hand, to your point, the people who have the damning admissions would seem to me to be pretty high on the list too. And the only conclusion I could draw is that they were just not prepped. I think even Saraf just kind of nonchalantly said, yeah, I met with you once a couple of months ago.
Awesome. How are the Celtics doing? I keep
Well,
seeing
but
you
you're doing
looking-
good. Up 23.
All right. Do you have to go soon?
No, you know what? They're up 23. It's not a great game. I'm when you see me looking sideways, I'll fully confess, I've got the Celtics game on, but that's okay. No, this is, I find this interesting.
I need a screen over here because everyone keeps telling me that Court TV is playing Kevin's video. I want to watch that right now. That's crazy.
Lemonade.
Crazy. I can't believe Kevin is getting on Court TV. That's
so embarrassing.
It's
embarrassing for Court TV.
He told me in private chat that National News was laughing at me for backing out of the debate.
Oh, please.
Which is wild.
Walked all over him.
I set up a
There's
debate
a guy
with
with
him.
a big ego, right?
I set up the debate with him, and I was like, hey, invite other people, and I'll invite Aiden, and da-da-da-da-da. And then he just posted on Twitter, oh, we're going to do this debate on Saturday during Aiden's lives. Like, Aiden streams every day at that time. And I was like, okay, well,
Right.
I'm streaming that day. We both have other plans that day, so neither of us could come. And he said, oh, you're backing out? I mean, well, I'll disinvite you to my debate. Bro, what? It was my debate that
And then he
I
called you
invited
difficult.
you to.
That was funny. Yeah, he called you
I
difficult.
add a quick vignette about Court TV, and look,
Yes.
I look, they put Wendy Murphy on the air, so say no more, right? And
Gotta
it's
tell
like
you
I rest
something.
my case, but I promised I wouldn't be all her tonight. But so I needed to watch these couple of witnesses just to make sure it was fresh before talking tonight. And the stream that I pulled up was the Court TV one. So this was their stream from yesterday that I watched today. And I forget who the analyst was, and she calls herself a judge, and because they were calling her Your Honor, which was weird. But and they had Saraf test. This is during his testimony, and about 7 minutes into it, which means nothing's happened because you know how these examinations go. And I mean, I've seen the jokes. We're talking about the forecast, and yes, it was snowing, and yes, there was this much, and yes, it was still snowing, and all of that. And they take a break, and they're say, wow, this is really methodical and careful, and and I'm sitting here saying nothing's happened. Okay, whatever. And when it got to the portion where Saraf said, she told me this is all my fault, I did this, and they went to a break. Now, mind you, we have a judge or lawyer hosting the show, and she has two analysts who are lawyers. And I assume, that they're intelligent important people in there, wherever they are. And they say, wow, this is like, wow. And the thing about it was 20 minutes into a direct examination. And for legal analysts to not even say, pump the brakes, this could be powerful. I mean, look, this guy's testifying that she made what could be perceived as a damning admission, but as the voice of reason here, you never draw conclusions until you hear cross-examination. Never. Ever, ever. You never go on one side. And especially when 10 minutes later, here's this guy saying, well, it was an oversight. Twice.
It reminds me of when Lally said that Karen Reed says on video that the Albert smashed John's head into her taillight and she watched it happen. And so many people were like, oh my God, that's crazy. Karen Reed said on video some ridiculous story. She's going down. And then you watch the video and that's not at all what she said.
All lies.
And it's like everybody who drew a conclusion based off what Lally says just made an ass out of themselves. And the exact same thing happened with what you just said when all of those court TV people were like, wow, really? She made an admission in front of the firefighter? That's crazy. And they didn't even wait for him to be cross-examined. Like, is this your first day in court, first day in law school? What is this?
Listen, the bottom line with court TV, I mean, look, a lot of people watch it, but they do have some degree of an obligation to put qualified people up there if they want to educate the public. And that does not include, Duke lacrosse truthers and, frivolous lawyers. I mean, look, I hate to go back to her, but if you give
you know
someone
what? People are in the comments
you
asking
need to
for
make
it.
your point, though.
Oh, well,
Yeah, people are asking for it. They want more Wendy. They're like, I'm here for Mark against Wendy.
Well, I
be a
found
great
another
debate.
one who doesn't offend me as much, but I'm troubled by her. This ex FBI agent that
here it comes.
some of you
Oh, Coffin Daffy. Coffin Daffy.
She blocked me. She blocked me.
No, I'm not blocked because I haven't come after her, but I've
I haven't either. I never went after her, and I'm already blocked.
Well, she blocked me and then unblocked me. That was funny.
She posted a video that I didn't see from her. Somebody put it online where it was an attempt to discuss the Proctor text issue. All right. And what she said in essence was, it's unprofessional. I think those were her words. Yeah. It was unprofessional, but everybody, and I'm paraphrasing, don't quote me on this, has bad days, privately does things maybe they're ashamed of. Maybe you call somebody fat or ugly. And, and it's bottom line, it was unprofessional. It doesn't mean much. And my response, which she, of course, never responds to because there is no response to this kind of stuff, is that it's not just that he's like a misogynist pig, okay, bragging to his high school buddies that I'm going to try to find nude videos of someone. It's not even that he wishes that she would kill herself. But I have a theory about that too, that's actually more important than just being disgusting. Because here's the thing. If their theory is that they're trying to protect the Alberts, right? That's the defense theory and all of these people. Well, so Karen is the patsy. She's convenient. It's not by choice. It's convenient. She's there essentially. Well, guess what? It's still risky, right? Because now we have to lie. We got to cover this up, and lying's hard. And to tack one on top of another for years is hard. So what would be the easiest thing for them if our Patsy's dead?
Yep. Just like JFK, right? I mean, Lee Harvey Oswald.
I wouldn't dismiss the, I wish she were dead as simply because it makes no sense. Like why
Karen?
Would
you frame Karen? You killed John O'Keefe. Karen's John O'Keefe's killer, case closed. That was their whole game plan.
So, but I had mentioned that as well. And if that wasn't bad enough, the illegal search of the phone, which of course discredits him going forward in any case. But perhaps most importantly, from the lawyer's perspective, the demonstration of absolute bias in favor of the
Boston cop.
Alberts
Yeah.
is on the phone.
Yeah. The Boston
Right
cop.
there.
Right there.
It's not some speculation. It's right there.
It's in text.
And, you know, so for her to,
And then there's also the gift to the wife.
the gift to the wife,
Yeah.
the false testimony about the relationships, I mean, look, and as I tried to say to her, yeah, this is kind of a big deal. It's not unprofessional. It's actually a disaster.
You have to mitigate everything though. I don't know why she's chosen a side the way that she has and mitigates anything that is damning to her side.
Yes.
I have a theory.
Oh, you have a theory too?
Yeah.
You go, you
Michael
want to go or you
Proctor's
want to get
wife's father was FBI.
Hmm.
So I can't prove it, but I've seen speculation about it. People think that they're connected, and I would not doubt that. That would make a lot of sense if you think about it.
See, my theory is, you know, it's similar to Wendy, but it's different. I mean, Wendy, you know, exploits a law degree. So, you know, she's the clown with the law degree. And the law degree gives her the appearance of credibility when in fact she has zero. Now this one, you know, is an ex-FBI agent, which gives her a little bit to the public credibility, although it's a little different because, you know, she's not a legal expert technically, but whatever. But she wants to get out there, you know, have, you know, a Nancy Grace style presence, if you will. And the way you do that is, you know, you make hot takes, you purport to be an expert, you take a position and you go with it. And once she's dug into this position, she doesn't want to say I was wrong, because then she looks less reliable as an expert because she doesn't really know what she's talking about. And if you look at all of her analysis, they're all basic conclusions. There's no analysis. It's, you know, she's guilty, like I told you. And you know, it's all circular nonsense with no substance. But you know, she has her conclusion. She's got to be guilty. And so everything that's contrary to that has to be poo-pooed. I would say probably short of something like a complete collapse, like Duke Lacrosse, which in that case, only one person can stand on the top of that mountain. And that, of course,
Wendy.
But if that's genuinely how if she was on FBI and she actually was like that in the FBI, then that means every time she thought someone was a witness, or sorry, not a witness, a suspect in a whatever case that she was investigating.
I don't think she investigated cases. I think she was like a field agent, like a firearms training or something.
So you don't think she ever investigated any cases?
I don't know. And I'm sure she's trained in, you know, general. I mean, I know a lot of FBI agents, but I know she's not like, I don't think she was like a case agent type of thing.
So then she has literally no expertise over this
That's precisely
matter. But if she did, like if that's the way she acted as an FBI, and if she investigated cases, which now I don't know, then it's quite terrifying, because then every time she thought she had a suspect for a case, she would then build the argument to prove them guilty, as opposed to look for all of the potential facts and things that would make that potential suspect more or less likely to actually be guilty. I mean, even I think all of us, we watch the other side. We want to know, okay, if you actually think Karen is guilty, why? Like, please tell me. I listened to Yellow Tales
because you're stupid for thinking she's not, and I'm not going to debate with you, so you're not worthy. That's
right.
Wendy
That's
way.
right. To rage quit.
Well, I mean, I listened to Yellow Cottage Tales, but nothing he said makes sense. So, like, for instance, oh, well, it makes sense that nobody at the party saw his body because it was hidden by a flagpole.
Oh, that's...
Sir, do you know how large John O'Keefe was? And you understand the difference between lying this way and a flagpole, which is this way? And so, and every excuse, okay, why didn't they find a single shard of glass? But then throughout the days, they were able to find all of these shards of glass. Oh, because of the snow plow and because of physics and the way that the car was hit and all of this stuff. Okay, why didn't they put up any crime scene tape? Oh, I'm pretty sure they did. It just blew it out of the way. Okay,
No
well, what
substance.
about the
No
dog
substance.
marks? Oh, I don't even think the defense is going to bring up the dog marks. Every
Remember that?
single, and then
And
he's
now
like, oh, the
they reward
220
that jackass
yeah,
who
and the
said that. Put
227
him on court TV.
timestamp. They're not even, the defense probably won't even bring that up. Literally nothing that anyone, any Karen Reed disliker, any person who dislikes Karen Reed, nothing that they have said so far has been accurate with the facts according to what I've seen. And if it is, I try to look into it. I try to go, what's that about? And it always turns out to be wrong. So
Who's going to be the one, because I'm blocked, to ask? And I love to ask Wendy questions. I'd love to someday sit down and have, an idiot conversation with her. But who's going to ask Wendy, as we know, who is the defender of women's rights and sex abuse and all of that stuff, what her feelings are on the misogynist pig Proctor, who took a woman in her worst moments of life, went through her phone looking to abuse her further by viewing and distributing what he was hoping would be compromising sexual or nude photos of her. Wendy, clearly you would agree that that makes Karen a victim, and presumably that makes Proctor somebody who should either be, publicly executed or something close, right? In Wendy world, we don't need a trial. We know he's guilty because of the text messages. And, if he doesn't testify, we should presume him guilty in, her world. Somebody should ask her about that and how she feels that should impact the case, about having a misogynist, pig, and whether she has any sympathy, for Karen, and whether she would represent her in a civil lawsuit, a federal civil rights lawsuit for violating her 1983 rights for illegally searching her property.
This is the woman who, in a tweet on X, was celebrating the idea of Karen Reed getting raped in prison.
That
disgusting.
I think that's obviously the worst one she's ever done. I mean, that's sick. I also found one that she called the lawyers maggots.
Yes, you did.
And people who support Karen Reed, them and the lawyers are all maggots.
did she
It's
spell
really disgusting.
Did she spell maggots like MAGATS? Was she trying?
No, not make America great. No, MAGGOT, maggots, like bugs and larvae. And,
yeah. She's someone who pretends that she's liberal, but she actually runs around in conservative circles. I found it's funny. She's like plays both sides.
Oh, interesting.
Yeah, she doesn't really take a stand on that stuff.
I don't know too much about her. I just haven't found anybody who is credible, who dislikes Karen Reed, who's capable of having a genuine discussion where I don't feel like they're below average intelligence, severely below average intelligence. And
they're not honest. I mean, that's the big thing. It's the lack of honesty. The
Grant Ellis debate with when he's getting angry and like screaming into the microphone, and like that's such a bad look. If you are confident in your opinion, then just say your opinion. And if somebody is saying something contrary to fact, wait for them to finish speaking and then explain how what they said was incorrect. If you're trying to interrupt them, that's because you are not confident that you'll be able to disprove them, and you'd rather just have them shut up. And so it's been
your point, Lauren, when you were debating Kevin, Yellow Cottage Tales, when your poise was just incredible. You just asked your questions, you had the conversation, you let him just fall all over himself, and then you just kind of kept following up very strategically. You were fantastic. It was a world-class effort, I got to tell you.
Thank you. It was fun. I was really sad that we didn't get to do the second debate because he stole my idea and then planned it on a day I was not available. And then
he called you difficult.
I was debating Yellow Cottage Tales, and on my channel I debated him, And then I messaged him again on X and asked for a second debate, and he agreed. And then he scheduled it and then I was like, oh, let's invite more people from both sides. I'll invite TB, I'll invite the Glare, I'll invite Young Jerks. I invited like several other people, and he invited a bunch of people. He invited K. Peter, he invited Coffin Daffer, he invited True Crime and some wine. He invited a bunch of idiots.
Probably boundless millennial, probably.
Yeah,
Feckless millennial.
and then eventually it was just anti Karen Reed people, because he scheduled it on a day that all the Karen Reed people were busy, and we told him that we were busy and that we would love to reschedule for any other day and time, and he just said, no, it's my thing, it's my event, I'm doing it. And I was like, okay, well, here's the screenshots of in the conversation where it's actually my event. And then he got all pissy with me, and I was like, okay, well, at least I don't lie about cancer. And then he tried to prove to me that he has cancer, and it was just a whole mess.
Yeah.
Oh, I'm glad you got that little dig in at him. That's good.
You tried to press him on who his sources were, and you mentioned a very specific individual. Yeah,
Yeah.
and he wouldn't answer that. Oh, please don't say that. Please don't say that. I
Yeah,
don't
he
want
got
to hear
very
that on my
upset.
show.
Well,
Remember that? He was panicking.
he
such a
did
ripper.
actually admit to me who his real source was. Some other person. I don't even. It just. But also, I found out that source got a lot of their information from Krusty Panties. So it's Krusty Panties downriver eventually, and you don't want to be downriver of Krusty Panties. Trust me. Yeah, and like to rely on someone who, okay, let's see, this woman has like beyond the abuse that she's perpetrated against her own loved ones, the way that she has manipulated court systems in the past, the way that she has taken court documents and altered them in order, so she took like court documents and then changed out the name of the plaintiff and the defendant to put her name and Aiden's name in order to convince Google that she had the copyright information to something. So under penalty of perjury, she has manipulated court documents. And this is the woman that you want to rely on.
Yeah.
For
And did she
facts?
admit that she did it too, right? On like a stream?
She admitted that. And then she's also she's a compulsive liar. So she, for instance, in the past, she has raised funds for specific purposes and used those funds for her own personal gain, such as like she said that she was going to sue Chili DeCastro. So she had this huge fundraiser for attorney's fees. She never paid an attorney. Instead, she remodeled her home.
Oh,
and then
sounds like Monica Cannon Grant.
Yeah. And then another thing, what was it? Oh yeah. Another thing that she did is she said, so Turtle Boy published he got some private documents from a legitimate source. And she told her audience, oh, those aren't legitimate documents. Those aren't legitimate documents. He manufactured those documents, but then she sued him in court over those documents and told the judge, well, he's not allowed to publish those documents because they're private and I don't know how he got them. So which is it, lady? Are they fake? Or are they private documents that he shouldn't have the right to? And then just to me personally, she has used the name Lauren DeLaguna to message at least 10 sitting political, like people on a school board and people in political positions. She's emailed them as Lauren DeLaguna to complain about Aiden. So she has lied about being me to email other people.
That sounds like some government COINTELPRO, what they used to do to the FBI did to the Black Panthers way back.
I mean, you could have
So she's a pathological liar that you are relying on for facts. That's the problem. It's not so much.
That's why I can't listen to her at all.
And so people are like, oh, well, you need to put away your dislike for her. You need to just put that aside and have the conversation. It's not my dislike for her. Like, I don't mind that she's morbidly obese and fugly as hell. That's not my issue with her. My issue with her is that she is a pathological liar.
Well, she said some things about Lauren that have kind of maybe justified the statement by her right now, because she gave her a numerical rating and it was ridiculous.
Oh yeah, she did give me. She told what she said was a 3.
Yeah,
If I'm a 3, I mean, like, I understand that I look like I just woke up. Somebody called me
you
pajama
look
girl in the
fine. Oh
comments,
my god,
which is fine. But
ridiculous.
I pray God every day. Thank you for making me not look like KP
Yeah,
tonight.
right. She's
Thankful
got the
for my
nerve. It's so
for
funny.
blessing me with this face as opposed to hers.
Yeah.
But yeah.
So I guess what are everyone's final thoughts? I guess tonight that they want to share. Why don't we start with Mazza Media?
I'll go right away. So, to Lauren's point that she made in her debate with Kevin a couple weeks ago, Lauren made a very fantastic point about the glowing taillight. That not only was it not shattered, it was not only appeared to be intact, but it was actually glowing red, which was indecisive evidence that it had not shattered at that point. Well, yesterday in court, Alan Jackson and David Yannetti got 2 police officers who were on the scene to confess or admit to under oath that they did not see any taillight at that scene, any shattered taillight. And then Alan Jackson followed up in his cross-examination of Officer Saffer. He goes, so you didn't see 45 shattered pieces of taillight either? No. And we know for a fact that there was much more snow when the state police arrived many, many hours later, which would have covered that. So if the Canton police didn't see it, the state police didn't see it on top of the snow like they so claim. So that was under oath, 2 police officers confirming that they did
They
not
didn't find it.
see taillight on the snow. That is massive evidence in this case, a massive thing to get on the record in this case. And those are my final thoughts.
And the prosecution, thanks to them.
Yep.
Yeah, put him out there, and then they keep Adam Lally keeps lining him up, and the defense keeps knocking him down left and right.
Beautiful. So I guess we'll go to Lauren now. What are your final thoughts, or even anything you want to bring up that you didn't get to discuss tonight?
My final thoughts: if you're going to try to make an innocent woman appear guilty because it's your job as a prosecutor, your boss won't let you drop the case, even though that's the right thing to do. And it is your job to make her appear guilty based off all the evidence you have. Then prepare for what the defense is going to say. Understand what the evidence is. Prep your witnesses, talk to your witnesses, show your witnesses the evidence that they are going to have to see before they are on the stand. I am really eager to see what comes of tomorrow. I'm really eager to see how what the jurors think of 34 Fairview. And it's going to be, so far, it seems like a very easy win for the defense. But then again, I also am praying for Karen, because it cannot be easy going through this trial. A lot of us thought that it wouldn't even get this far, that she wouldn't even end up in trial. But here we are. So I pray for her, and I pray for her family. I pray for her father every day. And I hope that they're doing okay.
Thank you so much, Lauren. And the attorney, Mark Bederow.
Just 2 things. One of which, just quick thing to what Lauren just said. If the office is telling someone like Lally, you're going to prosecute this woman, and he believes that she's not guilty personally, based on, for whatever reason, the evidence that he knows exists or doesn't exist, then he has an absolute ethical duty to say no. And if they say yes, then his ethical duty requires him to say no, and I resign, and I'm out. And if he goes the other way and says, I'm willing to do it, even though I think that she, may not be guilty or isn't guilty, then he is every bit as corrupt as Proctor and anyone else in this case. I don't know that he is like that, but what he can't do is try harder. And I'd have more respect for him if he was tanking the case, if that was it, which I don't think he is, by the way. But
That was another question. I'm glad you answered.
Well, let me address that real fast. No, I don't think he is tanking the case. Again, for what purpose? The answer is, I'm out of here. You think you're going to get promoted because you blew the big case and made a fool of yourself and made the office look stupid. So no, I think he is just, as we've been beating on him now for weeks, he's not up to it. And it is what it is. I don't think he's just a very He doesn't appear to be skilled and prepared. But the real takeaway that I have is, you know, you do these kind of trials. I've been involved in these, seen a million of these, thought about these things on both sides strategically. And if you're the prosecution, your whole case really is, if I can establish that this was Karen Reed did this in a car and knocked him over, then we're going to win, because the defense here is denying that entirely. They're alleging you're trying to make it look that way. She was framed. So really, from their perspective, the best thing that they can do is just do whatever they have to come out strong and prove, which I don't think they could ever do, introduce evidence in their minds that would tend to support that she did that. And they tried it. I mean, they tried to come out strong. They gave a terrible opening, but then they tried to call, you know, first responders essentially who should have given them that testimony, and they didn't. They are in deep doo-doo. It's only going to get worse because of all of these. You know, we know what the defense has with experts. We know they don't really have any great expert. We know that, you know, the body doesn't seem to match with the car. Karen Reed's car doesn't seem to match with what they're alleging happened. I mean, it's a minor fender bender taillight. I mean, there's no other damage. I mean, I could go on and on. The point is, they needed to have a puncher's chance here to come out strong, and they came out weak. And how do they even recover? I mean, calling a couple of more cops to say, well, I heard it too. I heard it too. What if they heard it too, but they also heard it, you know, or remembered it in April, like the other guy or something else? I just, you know, there's nothing going on here.
Yeah.
Yeah, that's the key. It's going to be a really difficult case for them to win at this
Yep.
point.
Virtually impossible. I mean, I told you this before we even heard anything. I mean, just on a reasonable doubt standard. Again, I mean, I can leave with this, with my, I guess, seventh final thought. I apologize. But you can literally, I'm not saying you should, but jurors could say, well, I think she did it. Okay. I think that's not correct, but okay. Well, what about this? What about that? You say, well, yeah, that's possible. I still think she did it, but you're right. That's possible. That's not guilty, because that's not proof beyond a reasonable doubt. There's no way they're going to get 12 people to say beyond a reasonable doubt, which, by the way, in Massachusetts has that extra clause, which must make prosecutors throw up, to a moral certainty.
Yeah.
We don't have that in New York. Okay. And, you know, it's reasonable doubt, which is bad enough, right? From their perspective, it sounds terrible. But when you add into a moral certainty, yikes, that sounds even worse for them.
It's going to be difficult. We'll see what happens. I can't wait till tomorrow, 9 a.m., see what's going on in court tomorrow. We'll be live streaming. I want to thank all of our guests, attorney, criminal defense attorney Mark Bederow. Celtics are up big right now.
22 in the third quarter. We're good.
Every time we do a show, they're kicking. We're gonna have to continue to do shows here.
Let's hope we're having this conversation in, you know, mid-June.
You're right, exactly. That's when it matters the most.
Thank you so much, and thank you, Mazza Media.
Parade if they win, okay?
Yes, thank you, Attorney Bederow, and thank you, Lauren DeLaguna, for being here. You're awesome. You are not difficult. You're so easy. You're awesome. I love you. Thank you so much for all of our guests for being here tonight. Amazing show, and all our listeners, the people who've been supporting us, sending us money. The guests can drop off. I'm going to read off some cash apps, and thank everyone for being here again tonight. Thank you so much for being here tonight, everybody.
Thank you.
Thank you.
Have a great night. Thank you so much.
You
Free
too.
Karen Reed.
Free Karen Reed. And again, this is Mike Crawford, the Young Jerks. I want to thank everyone who's been supporting us. We got some Venmos tonight. I noticed a lot of donations came into on the super chats. John Barron, Dennis Sweeney, thank you so much for contributing. I want to thank Furious, who became a new member tonight. Thank you. Debbie, who did a super chat, a super sticker. I want to thank Cam. He did a bunch of donations tonight. Thank you so much, Cam. Stephanie, who also gave us another donation. Thank you so much, Stephanie, tonight. Suzanne, I'm sorry I didn't get all these because I know there's a lot of questions here, but I think we got some of them answered. Hopefully, as many as possible. Suzanne, I want to thank you for donating tonight on the super chat. Thomas Nikolek, thank you so much for donating. And who's this one here? Vahala, $1.99. He said, just like Sandra Birchmore. Hopefully, we'll be getting some justice for Sandra Birchmore too. We've been covering that on the show as it's come on. I want to thank Ronnie for sending $10 tonight. Thank you on the Venmo app. He says, great show. Thank you, Ronnie. I also want to thank Mark R., who said, you great shows. Appreciate you. He sent $10. Thank you so much, Mark. Let's make sure I'm not missing anyone else here. Okay, those are the Venmos. I think I had some Cash Apps. Let's just check them out real quick. Again, I want to thank our guest tonight, attorney Mark Bederow. I want to thank Lauren DeLaguna and Mazza Media for being here tonight. And I want to thank everyone who's been listening and supporting. I want to thank Sarah, who made a donation on the Cash App. She says, thank you, Mike. Awesome shows. Thank you so much, Sarah, for the donation. And also, friend D, I'll just call them D. Thank you so much for the $10 donation tonight on the Cash App. Thank you so much. All right, I think that's it for the donations. I'm going to check one more time on YouTube. I always feel bad if I miss anyone. Oh, I think I did. We got another donation. Thank you, Sherry D. Sent another $9.99. Great show. Thank you so much. And now I'm just checking the other comments. The glare isn't on. You want me to continue tonight? You want me to put on the Plevin on Court TV? I don't even know how to search for it right now. I probably just want to watch that on my own. I think what I'm going to do is play a little more of this Sarah, the police, because that's what we've been talking about so much tonight. I'm definitely going to check out the Court TV later to see Kevin, how he did. Hopefully Nick Rocco cleaned his clock.
Do you think it's appropriate?
I think I'm going to close right now
an unconscious person
by putting this video back up. If I
can make
can
contact with other witnesses and begin discussing
hold on one second.
the situation unsupervised.
Can you rephrase that question, sir?
Do you think that's an appropriate thing to have happen?
I have no answer for that, sir. I don't know what you're asking.
Officer Seraph, when you go to a crime scene,
Yes, sir.
one of the first things that you want to do is secure the scene and separate witnesses so that interviews can be conducted, correct?
Sure.
You wouldn't want witnesses just cavorting together and getting their story straight, right?
Correct.
You'd want to avoid that at all costs, right?
Yes. Yes.
And why is that?
So they can't collaborate their story.
Yet there was a person walking from the area where a body was found in the lawn of a house, walking into the house to make contact with other individuals, correct?
It appeared that way, yes, sir.
Does that seem appropriate to you?
No.
Of course not. We've talked a bit about what you did and didn't hear at the scene from my client. At any point when you were at that location, did you hear my client repeating the phrase, I hit him, I hit him, I hit him, I hit him?
She said, I hit him? No, I didn't hear that part.
You never heard her whisper it, yell it, say it, or otherwise?
Not that I recall.
If you have heard that statement, you likely would have written it down, wouldn't you?
Yes.
You likely would have reported that to Trooper Proctor the next day, wouldn't you?
Yes.
You likely would have mentioned it in your grand jury testimony, correct?
Yes.
And you did none of those things because you did not hear that statement, correct?
I did not hear that, no.
Sir, you were 34.
I just want to thank a couple more people who sent some Venmo money. Megan B, $10. Thank you so much. She said, great show. YouTube. Thank you so much, Megan. And Darlene sent $10. She said, fantastic show. She actually said, thank you from Shirley Ann. I hope I didn't give that one away. And Ronnie sent $10. Thank you so much, Ronnie. All right. Oh man, I'm not. Oh wait, here we go.
Fairview for more than an hour before you cleared the scene, right?
Yes, sir.
You were at the location of the body of John O'Keefe.
Yes.
In other words, you just didn't stay in your cruiser. You walked out to where John O'Keefe was.
No, I was in my cruiser at different times. I
Must have been a bad question.
Okay.
You didn't just stay in your cruiser. At points, you got out of your cruiser, walked over, made contact with the women, and you were standing next to the body.
Yes.
And you were obviously looking around. You noticed some footprints,
Yes,
and you didn't even notice the lack of footprints.
that's correct.
So you were being observant at the area of the body
Yes,
and the area adjacent to the body.
yes,
You were looking for anything that might have been out of place,
yes,
anything of any evidentiary value, correct?
yes,
You never saw or otherwise observed or located a single piece of taillight material, did you?
No.
You certainly didn't see 45 pieces of broken plastic or taillight material, did you?
No.
You never located or otherwise observed John O'Keefe's missing shoe?
No.
Or any other clothing of his?
I didn't know.
Officer Schraff, did you ever think to look inside the house
No.
for that missing shoe?
No.
That never crossed your mind?
No.
You think that might have been a smart thing to do at the time?
Objection, Your Honor.
Rephrase the question.
Sure. Do you think that would have been appropriate protocol when dealing with a body laying on a lawn that is partially unclothed to look inside the house of the lawn?
No.
You didn't think that would have been an appropriate protocol?
No.
For you or anybody else?
No,
Obviously, you did not conduct a search of that house, did you?
nope,
And you're aware that to this day, no law enforcement officer ever conducted a search of that house.
I'm not aware of.
Yeah, just a moment, Your Honor.
Yes.
No further questions, Your Honor. Thank you.
Anything, Mr. Lally?
Briefly, Your Honor.
Okay.
Morning,
Morning.
sir. You were asking questions and you were shown a dispatch log, is that correct?
That's correct.
And dispatch log, as far as the Camden Police Department is concerned, are you aware of sort of how or when or who creates that?
Yes.
And can you explain to the jury sort of how that document sort of comes into being?
So when a call comes in, an officer is at the desk, and usually the first thing they would do is dispatch, get people going to the scene, and get everybody rolling as far as if they need FD, police, whatever resources they need, and basically then type in what the call is and who's going.
So fair to say it's more important to get assets allocated to a scene, especially in the case of an emergency, which is why someone's calling 911, than to ensure that the dispatch time is correct down to the second.
Absolutely.
Now, you were asking questions about different things that you heard the defendant say, correct?
That's correct.
And you were shown specifically some grand jury testimony from April 2022, in which you indicated during that testimony that the defendant stated, "This is my fault."
Yes.
And is that based on your memory of what she said?
Yes.
And you also testified yesterday along the same lines, correct?
Correct.
What you testified to before this jury, as far as your memory, is that accurate as to what happened on that scene, January 29th, 2022?
Yes.
Now, prior to this call, did you know Kerry Roberts?
No.
Did you know Karen Reed?
No.
Did you know John O'Keefe?
No.
Did you know Jennifer McCabe?
No.
Based on what you've seen as far as the dash camera, would you be able to differentiate between Jennifer McCabe or Kerry Roberts from that dash camera footage?
No.
While you were on scene, did you see anybody from 34 Fairview Road from that address come outside?
No.
Did you see anybody from any address on that entire street for the entire 90 minutes that you were there come outside?
No.
Now, you were asking questions about some different addresses on Fairview, whether they be 32 or 35. Do you know where either 32 or 35 is located in relation to 34?
It will be next to each other, sequential order.
Nothing further.
Nothing, Your Honor. Thank you.
All right, you're all set, officer. Thank you.
Thank you.
Yeah. Mr. Lally, who was your next?